With the due permission of the Honorable Judges, shall I start? Respected distinguished bench, Honorable Justice P.N. Prakash, retired judge of the Madras High Court and Special Public Prosecutor, National Investigation Agency, Honorable Dr. G. Jayachandran, judge of the Madras High Court, esteemed participants and one and all present here. A very good afternoon to each and every one of you. On behalf of the Tamil Nadu Dr. Ambedkar Law University, I, Purna, the court-hall manager of the final rounds of the Surana and School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University National Trial Advocacy Competition 2024. I am honored and with great excitement and anticipation to stand before you today as the court-hall manager of the final rounds of the competition. Today, we gather not just as spectators, but as witnesses to a formidable display of legal acumen and advocacy skills. This competition is more than just a contest, it is a rigorous trial by fire that showcases strategic brilliance and celebrates the art of advocacy. As we prepare to commence the exciting final rounds of this prestigious competition, it is my privilege to introduce the esteemed bench presiding over today's proceedings. We are deeply honored to have with us Justice P.N. Prakash, a retired judge of the Madras High Court and the Special Public Prosecutor for the National Investigation Agency. Lordship has a remarkable legal career that spans over 3 decades. Beginning with his enrollment as an advocate, he has served in various prestigious roles, including additional Special Public Prosecutor and Special Public Prosecutor for various government bodies and has been a dedicated educator and contributor to the field of law. Justice Prakash Lordship's expertise and dedication to the law are evidenced by his extensive practice in criminal law, his contributions as a guest lecturer, and his role as an editor for prominent law journals are remarkable. Sworn in as the additional justice of the Madras High Court in 2013 and as a permanent judge in 2015, Justice Prakash's career is a testament to his commitment to justice and legal excellence. Joining him on the bench today is Lordship Dr. Justice G. Jayachandran, a distinguished figure in the legal fraternity. Lordship's academic journey began at St. Mary's Convent in Velur and continued at Four East Higher Secondary School. He is a proud alumnus of the first batch of the 5-year integrated law course from the Law College in Chennai. Lordship's illustrious career is marked by numerous accolades, including sharing the first rank in his ML degree at the University of Madras and earning a doctorate in law for his thesis on trafficking and control of narcotic drugs in India. Over the years, he has held various prominent positions, including additional central government standing counsel and law secretary to the government of Tamil Nadu before being elevated to the Madras High Court as a justice on 2016. We are incredibly grateful to have both the justices for gracing us with their presence and agreeing to judge the final rounds of this competition. I would like to extend my heartfelt gratitude to all the participants who have prepared tirelessly to be here today. Your dedication, hard work, and passion for law are what makes this competition so special. I wish all the participants the very best and look forward to witness an exemplary display of legal acumen. We are deeply honored and look forward to an enriching experience for all the audiences as well. Before moving on to the rounds, I would like to clarify the participants with certain rules of the final rounds. Each team will get a total of 55 minutes to present their case. The division of time shall be as follows. The opening statement by the prosecution will be for 5 minutes. The opening statement by the defense will be for 5 minutes. And the examination in chief by the prosecution will be for 15 minutes. The cross-examination by the defense will be for 25 minutes. The examination in chief by the defense will be for 15 minutes. The cross-examination by the prosecution will be for 25 minutes. The closing statement by the prosecution will be for 10 minutes. And the closing statement by the defense will be for 10 minutes. The allotted time for each segment is the maximum that the respective speaker can avail of. Each of the speakers shall conduct either the chief or the cross-examination and deliver either the opening or the closing statement. Therefore, each speaker shall compulsorily conduct an examination and deliver either the opening or closing statement. The order of speakers and the examination and statements they would handle, that is the chief, cross, opening or closing, is to be intimated by the teams after the commencement itself, and this will be the final one. This is a knockout round. Thank you. If there are no further questions, we can begin the rounds with the permission of the judges.
Yes, team. Welcome. So glad to see you all because both 10 years we have seen a trial. Absolutely, because we both were trial lawyers and all our life. So 10 years, yes, 10 years since we are seeing a trial. So we are so excited that on a Sunday, we are going to see you promising trial lawyers like gladiators in an arena. Relax, relax. You know, the timeline which he told, it is just their timeline. You can be very, very confident that we would going to take the best from out of you. We are going to take the best out of you. Relax, relax, relax. The timeline is our making. They just have the power to modify the timeline and give you the best thing. So confidently do your case. All right. Wish you all the best. Both the teams, I wish you all the best. I ask my both judges.
Welcome, friends. In fact, we are more excited to see your performance and very eager to see you in action. Welcome, all the best.
The council seeks permission to proceed with the opening statement. Greetings to honorable judges present. It's a humble pleasure for the council to argue before the bench. The council seeks permission to address collectively the judges as your honors. The council seeks permission to collectively address your bench as your honors.
Yes, perfectly.
Much obliged, your honors. My co-counsel and I are here before this court in the case of State of Silver Shore versus Jackson Smith, and I'll be delivering the opening statement and conducting the chief examination of the prosecution witness, and my co-counsel will be conducting the cross-examination of the defense witness and will be delivering the closing statement, your honors. The prosecution is present before this honorable court in the case of State of Silver Shore versus Jackson Smith, who is being tried under section 103 and 109 of Bharatiya Nyaya Sanhita 2023 for the offences of murder and attempt to murder of Mrs. Rachel Smith and Ms. Maria Smith respectively. The prosecutors are approaching this court under the local jurisdiction of section 194 and read with 232 of Bharatiya Nyaya Sanhita 2023, which is formerly known as CRPC. Your honors, the prosecution case unfolds a sad and sordid story around a gruesome murder of a loving and caring wife and a mother by a cruel husband who didn't even put any efforts to take care of his family and recover himself from the addiction he was going through. On the fateful morning of 3rd July 2024, around 5:30, the grandparents of get a call from her grandchild saying that her own dad is killing her mother and she couldn't know what to do and she sought help to them. The grandparents rushed to the house only to see that their own only daughter to be unconscious and dead and see that their grandchild is even afraid of her own father. Winston Churchill, who is the grandfather of the granddaughter whose name is Maria Smith, also gave the complaint to the IO in the present case, and the Rachel Smith, who is the deceased in the present case, was taken to the hospital right after they came to the scene of occurrence, your lordship. There, it's the place where she was declared dead as well. Your honors, Rachel was more than just a wife. She was a loving, loving mother. She was a compassionate partner, and also a very precious daughter. Since the complaint has lost the only other daughter as well. Your honor, so the granddaughter. Yeah, yes, your honor. So the door was locked. So with the help of the iron rod that was present near the window, Maria Smith provided that iron rod to the grandfather through a window, and they broke the grilled door, which was locked, and they opened the door. Along for the wooden door, the house owner who was present at the scene of occurrence gave a spare key to open the house and get into the scene of occurrence. Yes, Your Honor.
No other access to the house.
Yes, Your Honor. There's a back door, but it was locked. It was broken from inside, but it can't be entered from outside, Your Honor. Yes, Your Honor.
You're on track.
Yes, Your Honor. Your Honor, in this case, we'll be proving that Jackson is guilty of both murder and attempt to murder with a series of evidences, which includes the witness statements, the exhibits that will be presented before the court, and the documents as well, Your Honor. So the witnesses will be presented in the given order. First, we'll be examining the complainant, Winston Churchill, who is the father of the deceased in the present case. Secondly, we'll be examining Maria Smith, who is the sole child eyewitness whose void test also been duly conducted. And thirdly, Dr. Abraham, who is the forensic expert who conducted the postmortem report on the deceased in the present case. And finally, IU of the present case to brief about the documents and all the exhibits in the case, Your Honor. Along with the exhibit, with respect to the exhibits, we'll be producing all the items such as iron rod, locks, all medicines, which has been recovered from the scene of occurrence, and that will be duly briefed by the IO as well. Your Honor, we seek justice not only to the deceased, but also to the only daughter of the deceased who has been in such a traumatic episode where she encountered her own father killing her mother. So we seek justice for both the deceased and the daughter for the same, Your Honor. And the counsel concludes the opening statement.
The defense seeks permission to address collectively the bench as Your Honor. Much obliged, Your Honor. Your Honor, the defense stands before you today not to evoke sympathy or to obscure the tragic loss of Miss Rachel. The case that is being put forth before this honorable bench is the present case is where it is firmly grounded on justice, law, and reasoning. As Thiruvalluvar rightly pointed out in one of his Tirukural, that which translates to English as even if one fault is found to, the virtuous will not be punished without a proper inquiry, just as the earth without due care. This rightly points out the ideology that the justice must be both balanced and also righteous, Your Honor. Thus, pointing this towards the Jackson's case today at the hand for the defense, for the honorable bench to consider, Jackson should be considered as innocent until proven guilty, Your Honor. The defense pursuit of fairness in disproving the false accusations against Jackson, which will emphasize the true justice, lies that finding the truth and not merely assuming guilt of Jackson. Your Honor, we are here as defense counsels today to demonstrate the prosecution's claim, which accuses Jackson of heinous crimes, that is, murder of his only beloved wife, that is, Mrs. Rachel, and also, according to section 109 of the BNS, that is attempt to murder of his only child, that is Maria Smith. Your Honor, both of these accusations on Mr. Jackson is without merit. Jackson Smith has been painted by the prosecution to be one of the violent as well as a person who's suffering from the addictions, Your Honor. But just this simplistic portrayal of Jackson Smith is not enough to prove what had actually happened on 3rd of July 2024. Your Honor, on the morning of 3rd of July 2024, Miss Maria Smith, who's the only child of Jackson and as well as Rachel, who was sleeping in her bedroom, Your Honor. In a very disoriented condition and also distress, she heard some noises of her mother, unpleasant noises, and got up to only encounter and witness that a person Your Honor, it is to be noted by this honorable bench that not her father, but a person, a man resembling like her father was strangulating her mother. So this is to be, according to the, considering the light, that is, Maria encountered all these things at approximately 5:30 p.m. Sorry, 5:30 a.m. Considering the light of it, Maria would have misunderstood, and the defense counsel will prove that in the proceedings, Your Honor. Your Honor, at the heat of this very issue, the question arises about the mens rea, that is the intention element. As per section 101, clause C of the BNS, for any act to qualify as murder, it is the accused should have intently inflicted injuries on the body of the victim, which in the ordinary course of action would have resulted in the death. So it is very pertinent to prove that it is very pertinent for the prosecution to prove that not just Jackson had committed the such and such act, but also it was based on a deliberate intention, Your Honor. Your Honor, the defense will also bring in the facts that to show that Mr. Jackson did not commit the murder as well as the attempt to murder, as he does not have any intention, that is the deliberate intention for it. Your Honor, it is not enough to merely allege that a physical act was committed, but it must be shown that it was also voluntary by Jackson. The facts will reveal that Mr. Jackson's presence at the scene was only incidental and was not deliberate. The supposed act of strangulation, attributed by the only eyewitness, that is Maria Smith, his daughter, was under extreme stress and a disoriented condition where she got up out of the bed, Your Honor. So it is not supported by a reliable evidence. Moreover, Your Honor, this defense witness would humbly submit before this honorable court a petition under section 353 of the BNSS, allowing Jackson Smith to testify himself as as a witness for the defense. Jackson himself wishes to provide a clear account of what was his state of mind, his intentions, and the true sequence that happened on 3rd of July 2024, Your Honor. Yes, Your Honor. Yes, Your Honor. We will also submit affidavit that is signed by the witness. We will, Your Honor. Yes, Your Honor. For the purpose of it, we'll provide one of the state copy to the prosecution side as well. The affidavit is attached with it, where the sworn is also taken. Yes, sir. Yes, Your Honor. We are sure. Your Honor, we know we are sure of what the consequences may be, and we wish to put Jackson Smith on the witness box. Yes, Your Honor. Your Honor, there is another request from the defense counsel. According to section 308 of the BNSS, we request the honorable bench to allow Jackson Smith to be seated all over the proceedings, Your Honor. Yes, Your Honor. Thank you, Your Honor. Much obliged. Jackson Smith is DW1, Your
What is the strategy like you're
Now, first, the chief examination of prosecution witness will be completed. They were requested to be, they request accused to be present in the proceeding, Your Honor, but I don't think they were requesting to examine the accused now, if I'm not wrong.
No, Your Honor, yes, much obliged, Your Honor. I was just asking a permission from the honorable bench to. Yes, Your Honor. Yes, sir. Much obliged, Your Honor. Yes, sir.
presence of the accused is permitted, just be present when the trial.
Yes, Your Honor. No, Your Honor, according to, there was no DW witness from the defense side, so we allowed him through a special petition. Can I proceed, Your Honor? Much obliged, Your Honor. Through the expert witnesses, the forensic analysis, and Jackson's own testimony, the defense will demonstrate the true events that took place on 3rd of July and the tragic misunderstanding of the only sole eyewitness, that is Maria Smith, Your Honor. Therefore, Your Honor, the defense counsels urges the honorable bench to be open to the truth, to consider evidence carefully, and to acknowledge Jackson Smith is not guilty of the murder of Rachel or attempted the murder of Maria Smith. The truth must prevail, and we are confident that through the due process of law, we'll get justice.
Counsel seeks permission to proceed with the chief examination of PW1, Winston Churchill.
Winston Churchill, Winston Churchill, Winston Churchill. Swear the presence of the Almighty God that the evidence which I shall give before this court shall be the truth, the whole truth, and nothing but the truth.
Could you please introduce yourself to the court and your relation in the present case?
I'm Winston Churchill. I'm 70 years old. I'm the father of the deceased, that is Rachel. My elder sister's son is Mr. Jackson, and
Could you please state why you're being present in the court and your involvement in the same?
yes, so Mr. Jackson has killed my daughter Rachel, and his daughter Maria Smith had called my wife Clementine regarding this, and we went there, and I filed the complaint for the same. So I'm present here.
When did this incident happen? Please state this date and time.
Yes, this incident happened on 3rd of July 2024, and the exact time when Maria Smith called my wife was in the early morning 5:50.
So, what did you do after going to the incident scene of occurrence?
Yes, so when she called us, we immediately rushed to the home. We directly went to the second floor. The door was locked, so we had to call Maria Smith, but she was afraid. She was not able to open the door at that moment. So the house owner had instructed her to open the window that was nearby. She opened the window, and I asked her to give me the iron rod, and I broke the iron lock, and then I opened the grill gate, and the house owner gave us an extra key,
And then with that, we opened the door and went inside. And Maria Smith narrated the incident that occurred. And then I immediately went to the bedroom and I saw my daughter was unconscious and she was immediately taken to the hospital.
Exhibit the Mr. Winston Churchill, do you recognize this rod?
Yes.
Is this the rod that you mentioned in the statement?
Yes.
The council marks request the court. Do you recognize this lock?
Yes, I do.
So is this the lock that you broke in the front iron door?
Yes.
The council requests the court to mark this MO. So you said Maria Smith described what happened. So what did she exactly say to you?
Maria Smith was very afraid at that time. She came to us and she told that her father was sitting on the chest of her mother and he was strangling her mother with both the hands. And then she also said that she was also strangled by her father, but then she pushed him and she ran away. She was very terrified at that moment.
Where was Jackson Smith at the time of incident?
So when I opened the door and went inside, he was sitting in the chair and he was also a bit disoriented and he was very tensed and he was not normal. He was a bit tensed.
So what did you do after seeing Rachel's body unconscious?
We immediately, my son Matthew and the neighbors took him to the PN Government General Hospital, took her to the government hospital because she was unconscious.
And when did you file the complaint for the same?
I filed the complaint at 8:30.
Do you recognize this FIR report?
Yes.
Council seeks permission to mark Annexure 1, the FIR as Exhibit 1, Peter 1. The council concludes chief examination and the witness is open for cross, Your Honor.
Council seeks permission to cross-examine. Much obliged, Your Honor. So, you are Winston Churchill, am I right?
Yes.
Okay. So, you are the father of the deceased person, that is Mrs. Rachel.
Yes.
Okay. So, according to you, on 3rd of July 2024, you received a call from Maria Smith around 5:30 a.m., right? I mean 5:50 a.m.
Yes.
Okay. So, who spoke to Maria?
My wife Clementine.
Okay. So, your wife Clementine spoke to Maria.
Yes.
What did she say?
She said that she saw her father sitting on her mother and strangling with both her hands. So she was very terrified. So we had to.
She said that her father.
Yes.
Okay. Point to be noted, Your Honor. Okay. Now, then how did you come to know about that incident when it was said to Clementine?
It was early in the morning. I was with my wife. She told
Yeah,
me,
yeah.
so we
You will
immediately
be
rushed.
Mr. Wife.
Yes.
I know that.
Yes.
I am asking. It was said to your wife through
Yes.
phone communication.
Yes.
So how did you get to know about that?
My wife told me that. Yes. Yes. No, the phone was in speaker, so I was able to hear it. Yes. My wife also told me the incident. I was also able to hear the conversation. The volume was loud, so yes, I was able to hear it. Sorry? Yes, after hearing that, Clementine also said to me, and then we rushed to the incident. That is what happened. I don't know the accurate distance, but the time it takes around 15 to 20 minutes to travel there.
So it takes around 15 to 20 minutes.
Yes.
I put you that you did not like Jackson's behavior, that is your son-in-law behavior, because he used to hurt Rachel and also Maria Smith, according to you.
Yes.
Is that correct?
I don't like his behavior.
Okay, thank you. So I put to you that because you are a concerned father and also Jackson was hurting Rachel as well as Maria, you asked Rachel to divorce him.
I did not ask to divorce her. I just, as a concerned father, I suggested her. I advised her. I advised her that whatever is best for your future, you should go on with it. I did not ask her to divorce her.
Suggested her.
I advised her on her
Why suggested?
good with.
Okay. But still you suggested or asked her multiple times?
No, I did not do it multiple times. I advised her whenever she asked me. I gave her an
How many
advice.
times she asked you?
I'm not very sure about how many
When
times.
she asked you, you suggested you suggested get the divorce.
No, not all the time I advised her. I just now
Now
said
you said-
no. I said I advised her once that when she asked me regarding this, that it is your decision, but take any decision that is upon to your welfare. I advised her. Yes. Yes.
That's
Yes.
so until you reached the house, until you went to the crime scene, where was Maria then?
Maria was inside the house.
Maria was inside the house.
Yes.
So let's assume she called you at 5:30 a.m.
She called me at
Sorry,
5:50 a.m.
Called you at 5
Yes.
50 a.m.
Yes.
So it took around 15 to 20 minutes.
Yes.
So let's say it took around like 6:05 or 6:10 a.m. for you to reach there.
I reached there at 6:30 a.m.
There at 6:30 a.m.
Yes.
Okay. So until then, where was Maria? She was inside the house with Jackson itself.
She was inside the house.
With Jackson, whom you are alleging to have murdered your daughter Rachel.
Yes.
Point to be noted, Your Honor. So when you entered the house, the crime scene, what was the condition of Jackson? Can you please describe it?
He was very tensed. He was not normal. He was also he was very disoriented. He was not very normal.
Okay, it was not normal.
Yeah.
He was disoriented. But okay.
Yes.
So when you entered the crime scene, right? So you, according to your statement, he was sitting in the chair.
Yes.
Did he ever try to harm you or any others who came with you inside the house?
No.
No. Point to be noted, Your Honor. Did he try? So when they entered, Winston with other people, when they entered into the crime scene, that is the house, did he ever try to harm them or the other people? Yes. Winston and the other persons.
No, he did not, because he was already.
Just yes or no? Is it
No, he did.
yes or no?
No.
The rest.
Can also add.
Oh.
Because you can't ask the witness, have you stopped beating your wife? Say yes or no.
Much obliged, Your Honor.
Say yes, you are beating your wife. No, I stopped beating. Earlier I was beating.
Can I proceed?
Proceed, relax, proceed.
Okay. According to what you said, that Maria came and said to you that all these things were happening after you went inside. So did Maria say that he prevented? I mean, Jackson prevented Maria from opening the door while you were waiting outside to rescue her. Understanding my question, or should I?
Can
Examination, you never said that. Why do you want to ask this question?
No. I'm just asking it for getting a relevance, Your Honor. To just say the condition of the Jackson.
Can you please repeat the question?
Okay. So did Maria anyhow stated that while you were waiting outside to rescue her, that Jackson prevented Maria from opening the door?
No, she was already very scared, so she did not mention anything like that. She was very scared. She came running and just narrated whatever happened in that incident. So we were not concerned about that.
Okay. So you took you took Rachel's body along with Matthew and went to the hospital.
No, Matthew and the neighbors took her to the hospital.
Where were you?
I was at the incident place.
Only you were there?
Me and my wife and Maria. Yes.
So Maria was not taken to the hospital?
Sorry, can you?
Maria, was she taken to the hospital? Because you are saying that you were at the place of incidents.
Yes.
You and your wife. So,
So-
whether Maria was taken to the hospital.
Once they took my daughter to the hospital, I went around to check if anything is there. I also wanted to inquire in the neighborhood whatever happened.
yeah,
So
I
I'm not
understand.
very sure about whatever happened at that place.
No, after you could have asked it to your wife Clementine also. See, you should have known as a grandfather, she is in a state of mental condition. I mean, she's in a weird condition. So, did you take her to the hospital to at least make her calm up, or whether to check any injuries? Did not take her.
As a concerned father, I was concerned more about my daughter at that point because she was already unconscious and she was taken to the hospital. I was very worried about her whereabouts, what happened. So I had to look into that first. So I was looking into that. So this part I did not concentrate much. I left her with with her grandmother, who is also very much concerned about her. So her grandmother took full care of her.
So,
Yes.
her very much concerned grandmother, did her take her to the hospital?
I'm not very
You're
sure
not-
about that because I had to go to the police station.
When did you leave the crime scene?
I don't remember the exact time because once I heard the news, I was very much disturbed, so I had to leave in a hurry.
Yes, Your Honor. Open.
Examination. Oh,
Apologies. And the counselor has just one question to the witness.
examination. What is the point you want to clarify?
We want to clarify about the behavior of Jackson towards Rachel in this. Since the counsel has told about the hatred that the complaint has towards the son-in-law. Can you please describe the relationship between Jackson and Rachel that you have witnessed before?
So since they moved to a different house, we visited them often. Whenever we visited their house, I found my son-in-law Jackson being very rude towards my daughter. He's since he's also a drug addict. He's been out of control. He's been somehow a little violent towards my daughter. He's been rude.
Is there any reason why they were having frequent fights?
Since it's their personal thing, I have not interfered much. But to my knowledge, whenever my daughter has talked to me, what she has said is that it's because she was a little disturbed because he was a drug addict and etc. Yes.
Not ask any question. That some additional thing. It's almost like a cheap examination. Say that. Otherwise, leave it. Don't have nothing. Got what you wanted.
No, Your Honor.
The counsel seeks permission to chief examine PW2 Maria Smith.
Maria Smith, Maria Smith, Maria Smith.
Of Almighty God, that the evidence I shall give before this court shall be the truth, the whole truth, and nothing but the truth.
Your Honor.
Yes, sorry.
The prudence of the only eyewitness, that is the child witness, must be established before taking the oath. The prudence of the eyewitness, the child witness.
All right, do you suspect that first of all?
Yes, Your Honor.
Ability to testify.
Yes, Your Honor. We suspect the prudence.
That the PP will satisfy us first.
Before taking, according to the procedure of BNSS, before taking the oath, the prudence must be testified, Your Honor.
Your Honor, we have mentioned in the opening statement that the void eye test has been duly conducted as well.
But show the proper relevant portion of PS. You're taking it through BNSS?
BSA, sorry,
BNSS, no?
BSA,
BSA.
BSA, Your Honor.
BSA. Yes, which version of BSA? This is an opportunity for us to learn PSA.
Your Honor, can we get back to you after? We'll get back to you.
Your Honor, if the council may mention the section for the competency of the witness, it's under section 124 of the BSA, which states the competency of the witness that child witness can also testify for the same, Your Honor.
Yes, please proceed.
Could you,
For age, what did she say? 13.
yes, yes,
What's the age?
please mention the age to your.
Age is 13.
13. Tender age. It's not tender, 13.
Could you please introduce yourself to the court and tell about your family as well?
I will also ask her, because they are questioning her very competency to testify. Of course, not tender to 13, but still you should satisfy us whether she understands what she is here for. These are the preliminary questioning which you'll have to put. When there's a challenge,
Much obliged, Your Honor. We'll ask the following question.
as judges, we should also be satisfied about her ability to testify. If not,
Yes, Your
we can put court questions.
Honor. Yes, Your Honor. Could you please yourself and tell about your family to the court?
My name is Maria Smith and I'm 13 years old. My father name is Jackson and my mother name is Rachel.
So, which standard are you studying, Maria?
I'm in 9th grade,
And
And-
which school?
Josephine School.
Okay. And can you describe both your father and mother?
Father and mother used to fight a lot. They were a good couple only, but after he used to drink alcohol and all, they used to fight a lot. End up fighting. My father was rude to my mother and also to me.
So, do you recognize your father there?
Yes.
So, what happened at the incident of 2nd July 2024?
On 2nd July, my father and mother went to the hospital and they came back home. We had dinner and I went to the bed. After that, they were talking. That's it on 2nd July.
The early morning of July.
I was sleeping. Around 5:30 a.m., I heard the sound of my mother. I woke up and saw my father was strangling my mother's neck and sitting on my mother's chest and strangling my mother's neck with both hands. I pushed him away and got a cell phone nearby. I called my grandmother and narrated the incident, what's happening here. He tried to strangle me also. I pushed him away, he fell down. And that happened.
From whose phone did you call?
The phone that was nearby, that was my mother's, I guess.
Okay. Do you recognize that person who strangled you as that person? Apologies, Your Honor. So, what did you do after that?
I called my grandmother. I narrated the incident. And they came to our home. I heard the knock of the door. I got scared and I locked the door. After that, I heard the sound of my grandfather outside. I opened the window and gave the iron rod that was inside my house. I gave the iron rod to my grandfather. He tried to open the lock and he opened the lock and came in.
So, where did you find your mother's body?
It was in the bedroom.
Okay. So, what did you exactly tell your grandparents when they arrived?
I said the incident, he tried to strangle me also, and he strangled my mother's neck, and my mother was in an unconscious state. That
So, what did your grandparents do after that?
they asked where was my mother. Then they rushed to the bedroom and they took my mother to the hospital.
So, what was your father doing all this while?
Was sitting. Sitting.
The council concludes the chief examination. The witness is open for cross-examination, Your Honors. Hi, Maria.
Hi.
Are you comfortable in answering the question?
Yes, I'm
We absolutely understand the pain that you're going through. So we are also here to get justice for your mother. So you can absolutely feel comfortable to answer the questions.
Yes.
Okay. So do you know what happened on 2nd of July 2023? Sorry,
Uh,
2024?
My mother and father went to the hospital for the treatment. They came back home. Then after that we had dinner, and I went to bed.
What were they doing, your mother and father?
They also had dinner, and while I went to bed, they were talking.
So they were talking.
Yes.
Absolutely. So they were just talking, a normal conversation,
They
right?
were talking.
Point to be noted, Your Honor. Okay. So on 3rd of July 2024, you were, do you remember giving a statement to a police uncle and police auntie who came on July 3rd, 2024? Do you remember the statement that has been given to them?
I gave a statement. I do remember.
You gave a statement. Okay, thank you. So on July 3rd of 2024, you got up around 5:30 a.m., right? Okay. So how was the lighting set? So it is in your bedroom.
Yes.
So how was the lighting setup? Night lamp was there.
Yes.
Okay. So you said, so you also called your grandmother after encountering a person who's resembling like your father, right?
No. I called my yeah, I
Yes.
called my grandmother while he strangled my mother's neck.
Okay. So what was the exact sentence? Do you remember what you exactly said to your grandmother on call?
Someone is trying to strangle my mother's neck.
So someone.
After that,
No.
Yeah.
Yeah, I'm understanding. So you were saying someone was trying to strangle your mother. Point to be noted, Your Honor. Now, you are saying that you saw a man resembling your father to have strangled your mother. So whether you were seeing his backside or you were encountering him from his front side like this,
side.
side view.
Yeah.
Okay. Now, so also, Maria, do you know what is meant by alcohol and drugs?
What is alcohol?
You know what is drugs?
Something that is bad.
Okay, how do you get to know about this?
Because of my father.
Because
of my family situation.
your family situation and your father.
Yeah.
Did you witness yours? So how do you get, because of father instance, can you please elaborate it to the court? How do you get to know about alcohol?
Because he was taking treatment, I know.
Who said you that he was taking treatment?
Both of my parents.
Both of your parents.
Yes.
Did your grandparents also said you about the same?
They know, it seems. They know.
You're close with your mother, your grandparents, everyone, right? So whether
I talk to everyone.
you talk to everyone, yeah. So whether they said you about your father drinking alcohol or whether they had said you about the drugs and addiction treatment.
My mother.
Your mother was saying it. Okay. Okay. So you were saying that around 5:30 a.m. you encountered a person resembling your father to have strangulated your mother. Okay. So around what's the time that you called your grandmother? What's the time?
I don't remember the time.
You don't remember
I don't
the time?
remember the time.
Okay. So let's consider, okay, the time in between, that is you encountering a person resembling your father strangulating your mother and calling your grandmother, what was the incidents that was happening in between both of this time?
While I tried calling my grandmother, he came near me.
Yeah, yes,
And he
I'm understanding that. I'm asking you what in between the time that you encountered that person and calling your grandmother, between that period of time, what had actually happened?
Yes, he tried to strangle me. He came near me. He tried to strangle me
He tried to strangle you before even you made a call to your mother, your grandmother.
while I was calling.
I'm asking what happened before that.
I don't
Before
listen.
making a call to your grandmother, what happened before that?
Sir,
What happened before you tried calling your grandmother?
was strangling my mother's neck only.
Only you were seeing that. All through those while you were seeing only that.
After that only, he came near me and he tried to strangle me.
Okay.
That's
Okay.
when I realized he was my dad.
Okay, Maria. So you were saying that he was trying to strangle you, right? So where was this place? Like, was it in the bedroom or was it in the hall?
He was in the living room.
In the
Living room.
in the living room. Okay. So after that, what did you do? You tried to push him.
I pushed him and he fell down.
He fell down.
Yes.
When you pushed him, he fell down.
Yeah.
So he was sitting in the chair after that.
Yes.
So after that, so let's from that point of time till your grandparents arrived, you were in the hall with your father. Am I right?
Mhm.
Until the point where you pushed him and he sat on the chair, to the point where your grandparents arrived to the actual scene, you were staying in the hall with your father. Am I correct? So did he, in that meanwhile, until your grandparents arrived, did he try hurting you? Or did he try doing something against strangulating or something? He did not do anything like that, right?
He was disoriented, like something
Yeah,
like
he was
that.
disoriented. Did he try hurting you at that period of time?
He
No.
came near me.
He came near you,
Yeah.
but that wasn't said in the statement.
He came near me. I mean, he came near me. He strangled me. But then I tried pushing him away and he fell down. He fell
He
down.
fell down, he sat on the chair, all that's okay. So now, until your grandparents arrived,
Within few minutes or within 10 minutes, I guess. So
that's
they
what I'm
came.
asking, Maria. Within that 10 minutes, he did not try to hurt you, right?
No.
That's correct. Okay, even when your grandparents came inside, was your father trying to hurt them also? Like Winston, your grandfather Winston, your grandmother Clementine, did he try to hurt them?
No.
No, that's all. So, okay. So before strangulation or after strangulation, you made the call.
I don't remember exactly.
Why? You don't remember that?
After I making a call, while making a call, he strangled me.
Did he make you to complete the whole conversation, or well, you were saying
I
itself,
just-
he strangulated you,
I said the incident what happened that day.
and then your father came and strangulated you?
Not while strangulating.
While strangulating?
While strangulating, I pushed him away and I narrated the incident.
Okay, Your Honor.
You would have finished your brief, but then this is a very interesting case where the defense has a statement, a previous statement, which says that a man resembling my father was sitting on my mother's chest and was strangling my mother's neck with her hands, seeing which I pushed that man. This is a previous statement. Forget about things for the audience, for everyone, because you people should know as trial lawyers, all right? Whereas in the witness box, she said that I saw my father strangulating. So this previous statement is contradicting her testimony in the witness box, is it not? The problem with you people is that you just cannot keep this previous statement on the left hand and the testimony on the right hand and ask the court to compare. See, in the previous statement, she has stated like this. That is not possible. What you should have to now do is go take the previous statement to her, confront her with the previous statement. That's called contradicting a witness under 145 of the earlier. I don't know what is the present, Hari, what is the present position of 145? 145 is used to be our 148. The present is 148. Please take 114, read. Now, this is an opportunity for you trial lawyers to understand this.
Are you speaking about the BNA?
BSA. PSA 148. Oh, 45 it used to be. Take 148 and read it.
Cross-examination as to previous statements in writing.
Mm.
A witness may be cross-examined as to previous statements made by him in writing or reduced in writing.
Wait. So she is a witness, right? There is a previous statement reduced to writing, right?
Yes.
Right? Come on.
And relevant to matters in question.
And relevant to matters in question. What is the matter in question? The matter in question is who strangled the thing, whether a man or father. So,
Yes.
right? Come on. Next, go.
Without such writing being shown to him.
Right. Even without showing the writing, one can contradict. Next.
Or
Or
being
proved. Correct. But
if it is intended to contradict him by the writing.
so you are now can be questioned even without showing the thing. But if you intend to contradict her, what is the contradiction? Here you say one man. Witness box you say my father. So there is a contradiction, is it not?
Yes.
So read this provision. But if it is intended to contradict him,
By the writing.
come on,
His attention must. Before the writing can be proved. Be called to those parts of it which are used to be for the purpose of contradicting him.
So you must have to bring it to his attention, this portion, that did you tell the police that a man resembling my father was sitting on my mother's chest and was strangling my mother's neck with his hands? So you must bring to her attention this particular portion. Ask for answer. Ask her answer. What answer she says. We'll see. Do it now. Doesn't matter. Even take time. This is the biggest problem is go near the witness, show it, and ask the witness. First, ask the witness, did you give a statement to the police?
Your Honor, that was already been asked.
Very good. In which case, you go to the police. Did you give this particular statement to the police?
Maria, so you have already stated that a police uncle and auntie came and you gave a statement to them. Is that right? So is this what the statements you gave them?
No, you do not have to think, because that particular portion, the police would have written their own handwriting.
Yes.
So the possibility of Maria knowing thing may not be there, all right? Because police never give a copy of the thing to them.
Yes, sir. So please read through this. You will be given time. So read through the statement and say if this was this being. Okay, so see here you have given it. When I woke up and saw that a man resembling my father sitting on my mother's chest and was strangling my mother's neck with his hands, seeing which I pushed that man, and also you have given here resembling my father. So was that you who gave the statement? Read it.
Correct.
It was your statement?
So, or did you tell the police this, the invert commas, that is, when I woke up and saw that a man, did you tell the police this? Ask her that.
Okay. So did you tell the police? I'll just read through the line. Okay. So see if it was the statement that was given by you to the police. When I woke up and saw that a man resembling my father was sitting on my mother's chest and was strangling my mother's neck with his hands, seeing which I pushed that man. Was it given by you?
Father.
You pushed your father, but here it is said as that man resembling my father.
I pushed my father away.
No, the question is, did you tell the police as what she's asking? We are not asking you what you gave in the evidence. Did
Was
you
this
tell?
You to the police?
Or police themselves wrote it like this? I don't remember. Very good. Excellent. So note down. That's all. All right. This is how it should be. She has got three answers. One answer is I don't remember. One answer is yes, I did give the statement. Third answer is I did not give the statement. Police themselves wrote the statement. In India, a witness need not have to sign a statement. Police can write any damn thing. That is why these statements are not treated as evidence in a court of law. What is treated as evidence in a court of law is a witness coming and giving evidence is treated. So these three things are there. So out of the three things, she has chosen the first thing, I don't remember. Doesn't matter. It will be noted down. Then this statement has to be proved. See, read the section. His attention must, before the writing can be proved. So how the writing, now, if she had stated that, yes, I did give the statement, which means the writing is proved. She has agreed that, yes, the writing is proved. If she says that I have not given such a statement, it is not proved. Now she has stated, I don't remember. So still the writing is not proved.
Yes, sir.
Right? Now the writing will have to be proved. How? I will tell you next. That's all.
Your Honor, can I please approach the
Yeah. Doesn't matter. Because trial lawyers have to know this contradiction, how to confront a witness with the contradiction. This is a fundamental thing. Fortunately, this contradiction appeared in this case, so we are taking a little time to take a class on you on these provisions of 145 and 148. All right. Never, seldom will we get such a text case of contradiction. Thanks, Hari, who explained this. He has brought this contradiction. Yes, proceed. Doesn't matter. Don't worry about the time. We told you that you're going to take the best out of you all.
Honor.
Yes.
Completed.
Proceed.
Completed, Your Honor.
Any re? Yes, witness. Put your next witness.
Counsel seeks permission for chief examination of Dr. Abraham, who is the forensic expert in the press.
Yes. Postmortem expertise.
Postmortem, apologies, Your Honor. Postmortem expert.
Dr. Abraham, Dr. Abraham, Dr. Abraham.
Before this court, shall be the truth, the whole truth, and nothing but the truth.
Could you please state your full name and your profession and your involvement in the present case?
I'm Dr. Abraham. I'm working as a medical legal officer at the KK Government Medical College and Hospital, Cardiff, and I'm the postmortem expert in this.
So, what time and date did you conduct the postmortem examination?
So I can
The witness, because this is a court witness.
Oh.
He has nothing under 45 of the Yes. Then don't have to waste much time on it. The witness could have any serious objection to the if we leave the witness.
Is this the document that you have prepared? The council humbly submits that the annexure 12 shall be marked as exhibit P2. So, what were your findings after when you examined the body? Indeed, Your Honor, indeed.
So as of this case, I found the body in a rigor mortis condition. Physics finding, I found this body in a rigor mortis condition, and later to add it.
What time the body came in?
Sir, the body came into the mortuary at 3:30, sir, on the day
3:30 on 3rd July.
on 3rd July, sir. And I started the postmortem by 4 p.m., sir.
4.
So yes, sir. So I also found the body with a bluish discoloration of the finger and toenails. And basic on the external injuries, I found the dark red contusion on the both sides of the chest. I also found a centric oppression in the middle part of the neck on both the sides. And in addition to that, in addition to that, on dissection, and I found that higher bone is commuted fracture. Adding to that, I also found a dark red contusion in the muscle on the both sides of the neck. Also find there are abrasion over the lungs part as well. Lungs parts. Chest, there are abrasion in the chest as well as there are abrasion in the within above the lungs layers. On dissection.
So from these findings, what is the cause of death that you have concluded?
So the injuries that might have possibly resulted in asphyxia condition that is caused due to the strangulation of neck by throttling and full force on the chest area.
So what does these injuries indicate? That you have mentioned that there are contusion in the chest area and the abrasions in the neck.
Yes. So what does it indicate? That first thing is that centric abrasion. So centric abrasion, there are different types of abrasion. So centric abrasion are usually caused by the fingernails. Okay. So fingernail that is seen on both the sides of the neck in the middle part. Okay. So adding to that, I also found there are some contusion over the chest part on the both the sides as well. So with this, I can infer that there might be a possibility of someone sitting on her neck, sitting on her chest part, exerting a full pressure over the neck part, causing the injury to have happened.
Can you please state to the court the time of death?
Time of death.
Estimated time of death.
So I have mentioned is that I found the body in a rigor mortis condition. So it is an inference of the time of the death. So a rigor mortis condition appear only approximately after 2 hours after the death, and it shall does not last long, more than 24 hours. So I found the body in that condition. So I can infer that the death happened on the day which I have post-mortem.
Counsel concludes the chief examination and open for cross-hearing.
Your Honor, can I approach the witness to testify that it was given by him?
Is it your case that she didn't die at all?
She died, Your Honor.
She's not alive?
She died, Your
To
Honor.
that extent you're sure?
Yes.
They're not substituted the dead body.
No, no, no. No, Your Honor. So, Dr. Abraham, can you say whether the statement was made?
Yes, madam.
Statement of report.
I'm sorry, Your Honor. Whether this report, the post-mortem report.
Exhibit C. What about the AR entry is there, I think. AR copy is there, I think.
Yes,
Is it
Your Honor.
there?
Yes, Your Honor.
What happened? Why do people? No, no. No, I will accept them.
Thank you, Abraham.
What is this one? Where is that? 20 pages, isn't it? This body brought into to me.
However, Your Honor, the AR, the time of the body was taken is like 10 a.m. and he was there in the mortuary conducting other post-mortem reports. So I don't think he can testify the exhibition of the same.
True, you would not have been there. So it's all right. Okay.
Can I proceed?
Yeah.
Okay. Dr. Abraham said, you said that you prepared this post-mortem report. So can you please state to the court what was the cause of death?
So as I
Much obliged. So so I put to you that it is the standard protocol that is being followed in autopsy report, post-mortem report, to provide the cause of death. Is that true?
yes.
Yes. Point to be noted, Your Honor. I put to you that in the standard protocol of preparing a post-mortem report, there will be time of death also. Is that true?
Not necessarily in all conditions.
Not necessary in all conditions, but you will place it in, you will also put the time of death with it. Is that true?
In most cases, not, we don't follow
In
that.
most cases. Point to be noted, Your Honor.
First cases, you don't follow it. That is
Ah,
not giving
yes,
You don't
you
follow.
possible time of death.
yes, sir.
So you said
I've
most
given the
cases.
inference of the time of the death.
So you said most cases. So what are the exception cases where you will not give the time of death? Can you please explain that to the court?
Depends upon the condition of the body that we receive.
So what was the condition of the body that you received of Rachel's?
In this condition, it is not. I found the body in a rigor mortis condition only, a normal dead corpse of a female.
Okay, so why was there no cause of death? You said exception conditional.
I have provided the sufficient testimony about the injuries and the dissection, what the scientific analysis I have made it. All these injuries are the possible causes.
Ask you whether your post-mortem report is probable. Exceptional cases give the probable date of death. What is so exceptional about this Rachel's body?
Please state the court.
That's what he's asking.
Yes.
Exception, it is a normal, it is not an what kind of a.
It's a normal body. Would be.
Yes, sir.
There is no exception.
Exception.
But still you did not put.
A body which is completely.
In such cases, we would be aiming to provide the time of the death, Your Honor.
Decomposed body.
In a kind of any mutilated body. In such cases. Yes, sir. Yes, sir.
Yes, sir. I put to you that in a standard protocol, there will be the seal of the hospital of in the post-mortem report. Is that true?
Yes.
Okay. Point to be noted, Your Honor. There is no
Contradiction.
okay.
Post-mortem you have given.
Sir.
The subject, I think, he didn't give the answer.
Yes,
You
sir.
have to see this. His eyes may be having infrared and ultraviolet.
So, Dr. Abraham. So can you see any seal here?
So I have attested with the original and true copy seals.
Original, anyone can attest your.
It is not a plain.
You can also attest original like this.
Madam, it is not a plain paper of evidence, okay? From our hospital, we have issued the original and true copy seals. It
Plain
is issued by.
can also be tampered in any conditions, right? You cannot say it was not tampered.
But I am sure that it is issued by my hospital.
Just now you said in a standard protocol, they'll be giving the seal of the.
It is not a. It is the standard protocol, not a mandatory.
Your Honor, it's a contradiction,
protocol.
Your Honor. Okay.
It is a standard protocol.
Yes, Your Honor. So can I say it is a standard protocol for having the signature of the doctor in the post-mortem report?
It is not to be. It is not necessarily to be signed.
Not necessary. Then how do you testify which doctor had made the post-mortem report?
It is issued from our hospital only. No?
Your hospital, there can be many doctors, right?
There may be only some bunch of heads who will be expert in this field, and they will be doing
There
that.
will be some bunch of heads, Your Honor, and these bunch of heads, anyone can sign in it. So So how do we find that which bunch of that person had signed in it?
We do maintain a separate register.
You do maintain a separate register, but that was not attested here. Okay. Point to be noted.
Communication is the post-mortem report.
No.
Ask him whether he has signed the post-mortem report. Where is the signature?
You would not sign the post-mortem report, but where is the signature, Dr. Abraham?
I didn't sign the report, sir. It is attested by our hospital.
You cannot say it like that because for a case like this, it is so.
Answering the signature not there. The explanation is he has attested it. All right.
Not
Now ask
attested.
him to see that original, true copy. How can it be original and true copy?
So how can it be original and true copy?
Well, children, you must as a criminal lawyer, your eyes must go all over the document. Okay, this is just a training ground for you. Original, contradictory, self-contradictory.
Yes, yes.
That's why you put it to him. You did not even conduct post-mortem of this body. Without conducting the post-mortem body, you have issued a certificate.
So we put it to you that since the sign is not there, since the seal of it is not there, since the cause of death is not there, since the time of death is not there, this is not an original post-mortem report and it has been tampered, Your Honor. I'm not asking you to accept. Thank you, Your Honor. Sir, Your Honor, I have certain questions.
More.
Yes, Your Honor. Okay. Sir, Dr. Abraham, since you conducted the autopsy, since you claim that
First principle was examination. Oil machinery, stop drilling. The moment you strike oil, start drilling more, it will explode. Hit oil, stop drilling.
okay.
You know, all right, you know, you have prepared everything. You tell us what are the things you have prepared for. We will say whether it is relevant or not.
No, Your Honor.
What have you prepared?
Okay. So, Dr. Abraham, since you claim to have done the post-mortem report, can you confirm which specific organs or tissues were collected for the viscera test? For the viscera. Honor, he's taken, Your Honor. Just a minute, Your Honor.
Find the visceral.
Page number 21, Your Honor. Like the bench to see the page 21 for the viscera. Can I show it? Your Honor?
No. The post-mortem report must say that I have collected the visceral reports and sent it to thing. It is not there in the post-mortem report.
Yeah, that's what I'm trying to prove, Your Honor. Why wasn't this attested to the post-mortem report?
Body will go to the post-mortem table. Will perform the autopsy. Take a note everything. Then at that time, he will remove the visceral organ. That is liver, intestine, kidney, brain, and put it in formaldehyde, seal it, and give it to the constable to be given to Tamil Nadu Police Department for thing.
Yes, Your
In the
Honor.
post-mortem report, he will say that I have sent the visceral organs, taken and sent. That is not there in the post-mortem.
Yes, yes, Your Honor. Exactly. That is why we asked him. So he should.
In your report, have you stated that you are saying? So someone else's visceral organ is sent. Some fellow or a drunkard would have died. That body will come, take his viscera and send it.
Yes, sure. So it's a standard form. So I put you that the standard protocol to prepare the required report before forwarding the viscera to the chemical analysis. Is it correct? But you did not come up with the standard format that has to be, the report form that must be sent within the post-mortem report. Didn't you? Point to be noted. Okay, another one question, Dr. Abraham. Were there any other injuries found in the body of the, the deceased?
No, there are no other injuries except the neck and chest area.
Thank you.
Anyway, this is very interesting. The witness did extremely well as a thing, and you also did very well. But then what you should understand is, these are all things you should study completely. Future is better.
Sure, sure. That's it.
Any re-examination, madam?
No, Your
Police, your
However, Your Honor, the oral testimony given under Section 45, the opinion of the expert given is still relevant in the court, Your Honor. Section 39 of the BSA, the opinion given by the expert in the present court is still relevant in the court.
It's relevant, Your Honor, but we have said that the whole postmortem report is tampered.
But the person who has prepared done the postmortem has.
We doesn't even know whether that person did the postmortem report because the signature was not there, Madam Counsel.
No,
Document evidence, Your Honor, then document evidence take precedence over the oral evidence. We pointed to this, Honorable Court.
I don't know. Yeah.
Thank you, Your Honor.
Counsel seeks permission for chief examination of the IO, Mark Antony.
Mark Antony, Mark Antony, Mark Antony.
First understand, the body at the time of postmortem, doctor will sample from the formaldehyde, give it to the postmortem constable. There will be a constable waiting. This fellow will take it to the forensic science department. Forensic department people will analyze that thing and they will report. That report will be addressed to the postmortem surgeon. He'll come back to this man. Then he would have noted down the postmortem injuries in a handbook. Every doctor will have a handbook. That handbook he will note down everything. Then after receiving the viscera report from the forensic, what he will do is he will prepare this postmortem. This postmortem report will not be prepared contemporaneously when postmortem is happening. No one can do contemporaneously, right? This will happen after the viscera report comes. He will read the viscera report. Then he will give the cause of death. Then he will say that cause of death is because of strangulation due to thing. And if he finds alcohol and all inside it, that will also be added in the cause of death. That is how ultimately the cause of death has to be given by.
And in fact, this postmortem report is not a complete report. There must be one more page where you would have said that opinion awaited, viscera opinion awaited, or after obtaining viscera report, this is the final report.
That's the second page will cut.
And in that, the postmortem doctor would have signed. So this document as such, we find that the next page is not there. An incomplete postmortem.
Anyway, we are not making much ado about this because first question I asked you is whether you are accepting that she died, Rachel died. It is not your case that Rachel has gone on a pilgrimage to Jerusalem and is likely to be back.
Your Honor, the defense would like to put.
If it is your case that she has gone on a pilgrimage to Jerusalem and is likely to return, then we can beat this postmortem report and say she is still alive. And you also considered that it is not a suicide.
Yes, Your Honor.
It's a homicide.
Yes, Your Honor.
So it may not.
Your Honor, the defense would like to put forth the alternate part of the story in the proceedings, Your Honor.
But in opinion, doctor is only a hearsay. Is only.
Yes, sir.
He's not a witness to the.
Yes, yes.
What is what? Hold through. Same button.
Can you please state your name and your position to the court?
I'm Mark Antony, and I'm the investigating officer in the present case.
So, Mark Antony, when and how did you receive the information about the present incident in the court?
I received it in my police station at 8:30 a.m. on 3rd of July, 2024.
Who gave the complaint?
I believe the deceased father, his name was Winston Churchill.
Okay. Do you recognize the document?
Yes, I do.
Can you please state the name of the document?
It's the first information report, that is the FIR.
It's already been exhibited but been corroborated by the scene. P1, the FIR has already been exhibited, P1 here.
Normally what will happen is the complaint will be That will be one. Okay. Based on it, the police also will prepare an FIR, even mark.
Okay.
Leave it. I mean,
we are not having the complaint. You have, therefore you have marked the FIR itself to the complainant. All right.
So what is the information that you received from the complainant?
So Winston Churchill had reported the death of his daughter. She was strangled by her husband, that is Jackson Smith, the accused in case.
So what did you do after receiving the information from the complainant?
So we went to the crime of scene, which is the house. So they resided in number 9/4, 114 First Cross in Cardiff, where we went and saw the daughter, and the body had already been sent to the hospital. So we went there and we made the observation, Mahasar, and the recovery and everything. By that time, I think it was 2:15.
Is this the observation Madras that mentioned in the statement?
Yes.
The council requests the court to mark Annexure 8 as observation Madras exhibit.
Could you tell PP how is it relevant and which portion of your Indian evidence act is it relevant observation? What is an observation, Mahasar?
Observation Madras is basically the description of the scene of occurrence in the present case.
By whom?
By the IO.
By
Who is
so
this?
it's a document. What the IO sees the scene of occurrence. It's relevant under which portion of Indian evidence?
The council takes permission to 30 seconds to just refer to the paragraph.
It doesn't matter. You must, because I know you would not have anticipated this question, because we are trying to help you people. No, I know that you people may find it very difficult. We'll come straight to the point. Take section 5 of the BSA, hold section 7 of Indian Evidence Act. Take section 5 and slowly read, you'll understand. Because you must all understand that every segment of evidence has to relevancy under section 5 to 55, old 5 to present 5. Read section 5.
Facts which are occasion, cause, effect of
The occasion, comma,
cause
Cause
or
or effect.
effect.
comma. See, every comma matters a lot. Please understand, children. Comma is not something which you just skip over. It completely changes the context and the meaning of the situation. Comma. Immediate or otherwise.
Comma of relevant fact
Comma.
or fact and issue, or what constitute the state of
Which constitute. What?
which constitute
When you read English, of which constitute.
the state of things under which they happen.
Full stop. So, which constitute the state of things under which happen. What happened in this case?
Murder of Rachel.
Where it happened?
At the house of Rachel.
So the IO goes there and sees his eyes all round, finds a sofa here, the body there, this here thing. So the state of things under which they happen.
Yes, sir.
So your entire observation, Magazir, is the state of things under which they happen. This one section is dealing with so many other facts, occasion, cause, everything, opportunity, all that will come in section 7. So you must be very thorough in section 7. All right.
Noted, Your Honor. Is this a recovery Mahadra that you mentioned in the statement?
Yes.
The council requests the court to mark Annexure 8 as a recovery exhibit a P6.
What did he recover from there?
Yes.
My lords, first it was
You can refresh your memory by looking into the map. You are not
Yes.
expected to, by 100 cases you would have investigated, right? So you got the benefit of refreshing the memory with under 159 of the old.
Noted, my lords. I first recovered a broken Godrej lock from the grill gate, and secondly, a steel rod, of the size 21 centimeters, and thirdly, a bottle of tablets, aripiprazole, if I'm pronouncing it right, and the bottle of tablet, another bottle of tablet, uh, pacetine, which is 2 milligrams, and door handle with lock, my lords. These are the 5. Yes.
I covered this under a story marker exhibit. So mark this as material of it.
Indeed, Your Honor. Since the lock has already been marked, I request the court to mark the medicine as MO 3 and 4 respectively.
Lock and seal also, you should say that this is the lock and this is the rod is sealed and I record the Gowri murder. These are all right.
All right.
Witness identifies. Right. All right, proceed.
So, whose statements did you record?
I had recorded, first the Panchnama was taken, 2. Joey and Rityush, both of them were neighbors. And later of Winston Churchill, that is the complainant, following Maria, the daughter of the deceased and the accused. They share a daughter. And thirdly, I believe it was the brother of Matthew. And fourthly, it was, may I please fresh? And the doctor, Abraham. This is the, and
The counsel concludes the chief examination.
After completing the investigation, I filed the final report before the jurisdictional magistrate.
Okay.
That's all. You may say that, all right?
Okay.
After along with the document.
Document.
That's how you complete it. Yes, Ross.
Your Honor, the defense counsel can lead to the.
Perfect. You don't get there.
So you are Mark Antony, the IO for this case, right? It's okay. So can you see this? So this is the observation master written by you, right?
yes.
Okay. So in this observation master, you have stated at this incident place, there is a high rate of criminal activity, right?
Yes.
So this was written by you.
Yes.
Okay. So you have also stated in the observation master in paragraph 2, line 3, on the east of the bedroom, there is a balcony of 2 feet.
Yes.
Yes, that's
Yes.
written by you.
Yes.
Okay. So in the same paragraph, in the last line, you have also stated the back door was broken.
But to be precise,
I'm just asking you, was this written by you? That's it.
yes, it was written.
Yeah.
My lords, I wanted to say that the back door was, my lords, the back door, which I've written, I've mentioned it for the balcony. So there was a lock on the black door, just connecting the
on.
2 things that the council had put forth.
Please, repeat.
There was there's a balcony which had a back door, my lords.
There's a balcony.
That's the
Then-
back door, my lords.
Can I ask her?
Yeah.
Then if you had mentioned,
We were forced to ask this question.
so you were,
Witness, you can't shut. I told you earlier.
yes, Your
You can't
Honor.
ask yes or no question.
No, I was just asking him whether it was written by you.
I'm not going to deny that he has written.
Yes, Your Honor.
Of that, you ask three. Did you see a balcony? Did you see that?
Yes, Your Honor.
Because he says no, you can contradict him with his written record.
Yes, Your Honor. Yes, Your Honor. Absolutely
So
understand.
you elicit from the witness.
Yes, Your Honor. So you have mentioned that there is a balcony of 2 feet separately, and also the back door was broken. So why was there a mention of it in two different places? If the back door was supposed to be of the balcony, you could have written it there.
I just mentioned like that. I'm not. Can I please?
Yeah, sure.
You have
I-
right to recur.
This was the meaning behind it. I don't know. This is the meaning behind it. This is how it's supposed to.
Show me.
It is just in two different places, my lords. However, it's the meaning.
Where is the observation, Melissa? Page number.
Page number 19, Your Honor. 19.
Yes. What is that you want us to see?
Your Honor, in the paragraph of third line, it says that on east of the bedroom, there is a balcony of 2 feet.
On the east of the bedroom,
There's a
balcony of 2 feet.
Yes, Your Honor. So that was mentioned in a different place. And at the same paragraph in the last line, it is mentioned the back door was broken. So it essentially means two entrance, like two exits to the same.
Back door was open.
Yes, Your Honor.
Broken it is, right?
Yes,
It's
Your Honor.
broken, my lords.
Broken.
But it is to the balconies.
So
The-
you're trying to fix that
There's only one.
door into balcony.
There's only one entrance, my lord. There are two entrances. One is through the main door, and one through the balcony. That is the back door.
So door was broken, you say.
Yeah, from the inside, my lords. The handle. It is broken from the inside.
Your Honor,
That's all that I'm trying to.
if Your Honor, if it is that that the IO is putting forth, then it would be reasonably expected to put the balcony door was broken, which was 2 feet.
My lord.
But that was mentioned in two different places. One is that there is a balcony of 2 feet, and at the last line it was mentioned the balcony.
They depend. No, but how does it improve your or affect your case? Supposing is it your case there is no door in the back?
We are meaning to prove that there are two doors, two ways of entrances. One is through the back door and one is through the main entrance.
That's it, there's a back door.
We are actually meaning that balcony is different from what the back door the IO was intending to.
Okay, let the balcony be different. How does it, what is your difference you're having in your mind, sir? Because one thing you understand,
Yes, sir.
this court has got power to conduct the local inspection.
Yes.
Supposing if you are going to convince us that this observation Magadhar is a path, is not thing, we will come to the place of investigation and find out whether there is a door at all, there is a balcony at all. That we have the power. So they are not fools to write something which is totally a thing. So what is it you are trying to?
Sir, Your Honor, that will be proved through the proceedings of the case, which will have the.
Now what is it you want from him?
I want from him that the balcony is different from the back door that he's intending to say.
We put a suggestion to him
Yeah.
that the balcony is different, there is a back door is different.
Yes, Your Honor.
Let him say deny or accept it.
Yes, Your Honor. So I put to you that the back door that you mentioned in the last line of the observation master is different from the balcony of 2 feet that you mentioned. Is that correct?
No.
Your Honor, can I proceed? So, IO, can you please explain the exact steps that you taken to preserve the crime scene of the particular case?
The crime scene, we had sealed the entrances so no
Okay.
one can trespass. The usual procedure that we do, we seal the entrances so no one can tamper with the crime scene. And the body had already, as I mentioned before, it had already gone to the hospital, so we didn't have to take any steps on that. However, I did send a particular person to the hospital.
No, after your ensuring that there was a seal, what was the next step that you take?
In
No, Your Honor, I just wanted to know, ask whether he knows the procedure or not. That's
Not writing a promotion examination. Please understand. If you go take up a promotion examination from inspector to DSP, The question is asked. You are subjecting him to cross-examine in the court of law.
Yes, sir.
Take advantage of whatever he has not done. Don't keep asking him because procedure is thing. Straight confront him.
Yes, Your Honor. So was videography and photography taken of the crime scene after once you
Did you take photograph?
take the videography and photography of the crime scene?
Videography, photography. Can I just take a moment to recollect?
Yeah,
Because,
sure,
In
sure.
your case diary, consult your case diary. Taken or not taken? For it. If you say, see, if you're not taken, say not taken. If you say taken, we'll ask you to produce the negative. So don't get caught by perjury.
my lords, I don't believe it was taken. The video.
Question of you not believing. You're not.
No, it was not taken. It was
You
not
must
taken.
understand, you're not, you're an investigating officer. It is not your belief that matters. The question is what you did, what you did not do. That's all that matters. Other witnesses can say, I remember, I don't remember. The other witness has got the indulgence to say, IO doesn't have that indulgence. You have to tell us whether you did or not. Say, don't waste the time of the court.
It was not taken, my lord.
That's all. Next, proceed.
It was not taken. Point to be noted. Your
Yes,
Honor.
it's noted.
Okay. So you observed that the back door of the house, I mean the crime scene, was broken. So what is your findings upon that?
The inside of the back door.
Side or broke? Picture and show. Back door.
Taken it when? You have taken it.
No, the
You
prosecution.
can confront a witness with a cross-examination. To contradict him, you can take a rabbit from the hat and show.
No, Your Honor, it's a prosecution's
Good.
exhibit.
Good.
It's in the recovery master. Yeah, it's a 5 items are recommended.
So this was the picture, right?
Okay.
So if I go by the picture, here is in one handle. Out, there would be a handle.
Yes.
So according to the picture of the back door, Your Honor, here inside there will be a handle. Outside also there will be a handle. Is that correct?
Yes.
Point to be noted, Your Honor. Okay. So what was the findings? Why was it actually broken in the first place?
Madam, any house you take, there will be few things that are broken, that are not broken.
That's
But this was
correct.
not, since it's broken from the inside, it had nothing to do with the investigation. From my years of experience, that's what I understood, and it had nothing to do with the
Was it connected
investigation.
with the case? You should have, because
It
this
wasn't.
is one of the important piece of evidence, because the back door, the front door being open, there was reasoning for it. Because Winston came inside the house. But for the back door being open, there was no reasoning for it. And we expect the IO to.
The back door was broken from the inside of the house. Anything can happen inside a house. But if it was broken from the outside, like if it were to be broken from the outside, then we would have taken it as an evidence. But it is not, and therefore we didn't have to investigate.
So how can you say that the door was broken from inside?
Madam, I entered the house. I saw that it was broken from the inside. As you said, the handle is on to both the sides.
Yes.
It was broken from the inside. It was not broken from the outside.
So anyone can open the door. Even from the outside, they can open the door. Even from the inside, they can open the door.
No, madam, it was broken from the inside.
No,
It-
if
was
I
broken-
was if I was about to break the door, since there was an handle outside too,
Madam,
I
the
can enter
lock
from
was not broken. The handle was broken. These two different things. The
but in the
mechanism of
but
a-
in okay, but in the observation, Mahasar, that you have given, it was said as the back door was broken.
yes, madam. I still
Yeah.
agree with that. The back door was broken, but it was
Yes.
broken from the inside. And there can be a mechanism in certain doors where the handle could be broken, but nothing happens to the function of the door. And that was the case here.
If to my limited knowledge, Your Honor, I would say door is not that of the handle. If it was handle, you should have mentioned the handle was broken.
Madam,
But here it is said as the back door
Madam,
was.
I wrote the observation report, yes, and I mentioned it as back door was open, but this was the meaning of it, and I'm trying to clarify it here.
Okay, so did you find any other footprints, fingerprints, any details of that?
No, madam. As I said, there was no entry or exit of the door. Both the doors were locked, so there was no need to take a.
But the back door was essentially open,
Madam,
right?
again, coming back to that, the back door was open does not mean the door, the handle, the door did not function. As if there were to be an entry from that side, I would have taken a
Was
fingerprint.
it like okay?
Madam, it was not open, it was broken.
It was broken. So it was not even opened at the first. It was locked.
It was locked.
It was locked.
Yes.
That wasn't open.
No.
So you're asking like so according to the cause of death, it was strangulation, right? So According to, as you are IO, according to section 53 of the BSA, the investigation officer should request the accused to be taken to the hospital. Did you do that?
Not BSA.
I'm real sorry, Your Honor, it's BNSS. So according to the BNSS of section 53, you should request the accused for taking him to the hospital. So did you do that?
Taking him to the hospital, yes.
Did you take accused to the hospital?
I did not take the accused to the hospital, but I sent someone, I believe a sub-inspector, to take care of that.
So what were the findings after taking the hospital, taking Jackson to the hospital?
Everything was found to be normal. There was no, I believe he had faced some giddiness and nauseousness right at that moment, like before, just at the commission of crime, if I may, that particular timing. But other than that, it's just he had a history of issues, and the doctor had said that he was in an unsettled nature. So that's all.
Okay, so there is no injuries intended to Jackson.
No injuries.
Am I right?
No injuries.
Okay, if you are saying everything is normal, but still he was in disoriented condition and giddy and all those things,
Just mentally.
you should have given it in the report, right? Where is the report?
What report?
No, Your Honor.
He's not the medical officer.
No, attesting the report, Your Honor, that he was in a normal condition without any injuries. The accused was in a normal condition without any injuries.
Right. The doctor would have given the report.
Yes, Your Honor.
According to you, that report has not been filed.
Yes, it has not been filed.
It has not been filed.
Yes, Your
And
Honor.
what do you want to say from that? That is, you want to say that you have not filed it because it is advantageous to you and
Yes.
disadvantageous.
Yes, Your Honor. That is what. Yes.
Put a session. Is saying that did you ask him to see the filed report? Have you filed the examination of the accused report? He will say no. I put it to you that you have suppressed that report because if it is filed, it will be advantageous to the defense, disadvantageous. He will deny it. That's all.
Yes, Your Honor.
Finish. I owe nothing much.
Yes.
And you got a very clever IO who is ready for promotion to SP, not DSP.
Yes, Your Honor. So I put you in suggestion that
Ask
you,
her whether did you file the medical report.
so did you file the medical report in the first place? No. So I put to you that you did not file the medical report in the first place because it could be in the disadvantageous position to you, but it could have been an advantageous position to the defense side.
No.
Is that right?
No.
I deny that.
No. Yeah,
We can draw inference.
Completed.
Over.
Over yours.
Important thing you left. PW2 stated, I don't remember.
Yes, Your Honor.
What did he say? He said that I don't remember. So that statement has to be proved. How to prove a statement? A statement can be proved by the person who spoke or by the person who heard.
Yes, Your Honor.
Right?
Yes,
Supposing if I'm going to shout at you, idiot. Two things. Either I should say, yes, I called her an idiot. You should say, yes, he called me an idiot. Is it not?
Yes.
So supposing I were to say that I don't remember, I will call you idiot. Who is the other person? He is the other person. Go, prove it.
Okay. Yes, Your Honor.
The statement. Take PW2 statement and prove it.
Yes, Your Honor.
Go.
So this was the written statement that you collected from Maria Smith, who's PW2, right?
Yes.
So here we have written that.
Not tell you. Man resembling my father was saying that.
So did Maria Smith that is PW2, gave you the statement that when I woke up, I saw a man resembling my father was sitting on my mother's chest and was strangling my mother's neck with his hands, seeing which I pushed that man. So was this the exact statement that she gave you?
Yes.
That's all.
Yes. No, point to be noted. Complete.
That is how you proved that statement. All right.
Yes.
You proved the fact that Maria told the inspector this one. Because
Yes.
Maria said she doesn't remember.
Yes.
Three contingencies we said. I don't remember. I told the inspector. I did not tell the inspector. So in two cases where I don't remember, I did not tell the inspector, he has to be confronted with this.
Yes, yes, Your Honor.
Maria had stated, yes, yes, I did tell the inspector, this is not, the exercise is not required.
Yes, 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 yes. Completed, Your Honor.
What about the second charge?
Second charge,
Regarding, I was done regarding the attempt to.
Attempt to murder. That is fine.
DP wouldn't say.
Your Honor, can I?
All right, nothing.
Okay.
Go to. Yes, inspector. You'll get promotion soon. All right. 10 minutes break. Court adjourns for 10 minutes.
All of you are requested to take your seats. Please don't go out.
Put the work. You close your eyes.
The council seeks permission to address the bench as your honors. Thank you, your honor. Can you please proceed to the chief examination of the accused, Jackson?
Jackson, Jackson, Jackson.
Good evening, sir. Please state your name to the court.
I'm Jackson Smith.
Can you please state where you're at currently?
I'm at the court right now.
Louder, please.
Yes, Your Lordships. I'm at the court right now.
The gallery, the public court is the public.
Can you please state where you're at currently?
I'm at the court right now.
Can you please state the reason why you're here?
I'm being accused of murdering my own wife, whom I love.
Can you explain your relationship with your wife, Rachel?
We have our share of fights, but at the end of the day, we love each other. And I think that sums up well.
Can you explain your relationship with your daughter, Miss Maria Smith?
Maria Smith is my whole world. And I think any father would love her daughter to the end of the world. And I think that's exactly what Maria is to me as well.
Where were you on 2nd July 2024? That is the day before the death of Rachel.
I have been advised to come for a regular checkup every 20 days. And yes, we did go to the hospital.
Please, can you explain as to what happened after returning home on 2/7/2024?
I witnessed the most gruesome thing I've ever witnessed in my life on that day. The night went normally, wherein we had a dinner and Maria went to sleep. I was talking to my wife on the couch, reminiscing about how good our life was for the past 15 years. And we went to sleep, and I was in a deep sleep. I didn't see the time when I heard Maria's voice, and I woke up to see somebody strangling Maria. And I didn't know what to do. I was paranoid. I was in a state of shock. I went and pushed him away. We had a squabble wherein I pushed him and I tried to hit him, but his physical strength was obviously higher. So it scattered everything around the room, and I saw him escape through the back door. But my priority was not to catch him because my wife was literally unconscious in front of me. So I tried to wake her up. That's when I think Maria woke up. But I didn't know it was Maria, and considering my alertness was too high, because I just had an intruder and I saw him strangling my wife. I didn't know what to do, and Maria was approaching me, and I didn't know it was Maria, so I turned to her harshly. And from then on, she's not able to look to me in the eyes because she's so scared of me.
Honors, can I please make the accused observation to verify the schematics of the house?
So should know the topography.
Simply to verify.
No, you can't. It is, see, please understand. Observation magazine is magazine returned by the IO. Is what you saw. Now, what do you want? Which proof of fact? What fact you want to prove?
It is with respect to the back door and balcony.
So let it with me in my house. There's a door in the front. There's a balcony behind. There's a door.
Can you explain the schematics of your house?
Indeed. Considering the interaction between the two, the clarification is regarding the back door. Facing my bedroom, towards the east is a back door, and towards the west, that is directly opposite to the back door, is a balcony. And it was the back door through which I saw the murderer escape.
That's all I don't know. Open for cross.
That's all.
Yes.
This is,
Much of like
it's a booty for you now.
Can you repeat why did you woke up or like how did you woke up? Yes, I was in a deep sleep and I heard Maria's voice. Maria's voice, right. Oh, I'm sorry. It's the wife's voice. Then what happened? I meant my wife's voice. I meant I meant Rachel's voice. I meant Rachel's voice. And that's exactly when I saw her being strangled. Strangled by whom? By an intruder. I didn't know who he was. It was
From where did he enter?
through the back door, I presume.
In the previous statement, it was mentioned that there were 2 floors.
Yes,
So the person climbed through the balcony through 2 floors, right?
through the back door.
Through the back door. The back door is in the balcony. So a person climbed in the balcony, right? Through 2 floors.
Not in the balcony. The balcony is on opposite of the back door. I know my
You just
house.
said it is in the balcony.
No, I did not.
Yes, you did. Proceeding, when you came back home, was someone else present in your house?
When exactly?
When you came house on the particular day of the incident,
Right?
except you and Ritual, was there anyone else present in the house?
That is the previous day. You mean on the second?
Yes, yes.
On
Your
the second, when he came returned from hospital,
Was someone else there?
No, it was just Maria.
All right. So how is your relationship with Maria?
Yeah, just a father and daughter's bond. And I haven't been able to connect with her that well regarding the recent days, but I've always been loving towards her.
So, okay. What is your occupation? What is your occupation?
I own a washing machine repair store.
Okay. What is your daughter's age?
She's 13 years old.
Okay. Is it true to say that you are addicted to alcohol and drugs?
I was addicted to alcohol and drugs.
Okay. You are not now.
Yes, I'm not.
All right. How's your relationship with Maria and Rachel?
Yeah, it was going good. We had a share of fights, but at the end of the day, we end up loving each other. So,
Is it true to say that you both were having fights regarding these drugs and alcohol?
not necessarily. It was other quarrels as well. You can expect it in any household, if I'm not wrong.
Can you explain some other types of quarrel except this alcohol and drugs?
It could be anything. It could be a little spending on my side or her side that I'm angry about. Anything like that. I cannot
Is it true
particularly
to say
point
that
it
you were admitted to the hospital for your addiction?
6 months back, yes.
Okay. Is it true to say that on the same day you went to the hospital with Ritual on 2nd July?
Yes, I did.
Why?
For a regular checkup, which was advised by the doctor for 20 days each.
For what?
Regular checkup?
Regular checkup. For each 20 day you are having a regular checkup.
Yes, because it's a serious thing that I was admitted in the hospital prior to 6 months. So they wanted to make sure I was all right for every 20 days.
That means you are not fully recovered from your addiction.
Just to make sure I'm not relapsing, it was done so.
So it was for what? That is what the courts want to know. You are admitted for what?
Just to make sure I'm all right, which it was done in the previous day and it turned out to be all
I'm
right. So
asking why were you admitted to the hospital?
in the first place, during
Yes.
6 months back,
Yes.
because I had an addiction for drugs and alcohol, which I've recovered from now.
Okay. Proceeding, why is your daughter, Maria Smith, claiming that you were strangling her mother?
I presume so because when Maria woke up, when she came afterwards, I was trying to wake my wife up because I saw that man escape to the through the back door, and I was trying to wake my wife up because I just couldn't let her go like that. And I think she presumed that I was trying to harm her because she saw her unconscious lying down on the floor, and my daughter was just confused, I guess.
So just for clarification, when the man ran out, the door was open or closed? Like when he went out, he closed the door and then went off?
I didn't notice. I just saw him go.
Okay,
out
you
to
just
the-
saw him going from the 2nd floor.
Yes, I
He
did.
just jumped from 2nd floor.
I don't know.
If that's the story, then proceeding, when you saw that your wife was unconscious state, what did you do for that?
I tried to wake her up, and that's when I felt someone near me. Apparently, it was Maria, but I didn't know it then. I turned to her harshly, and she started backing away. And I heard her call somebody, and I was in utter shock. I wasn't able to comprehend anything going on, which is understandable for anyone who faced with such a situation. So I was already tired from the fatigue of fighting off a man who was much stronger than me.
So you fought with the man.
I did fight with the man. I didn't fight with the man.
You did not fight with
I
him?
did fight with
You
him.
did fight with him. Okay, then how did he went off?
Because he was much stronger than me. I was already
Can you
tired.
explain his height and all of that?
He looked similar to me.
Was his height longer than you or whatever? Can you explain
he
something
taller
about
than-
him?
Was he taller than?
Was he taller than you?
No, I think he was approximately my height.
Okay, what's your height?
174 centimeters, I presume.
All right. So after that, you saw that your wife is in unconscious state. Did you make any effort to take her to the hospital?
I was in a state of shock and I heard Maria call somebody. So I knew help was on the way. And Maria was already scared of me. The slightest of movement from my side scared her so much. So I just sat down on the chair
So
and
it was important for you to not scare Maria and let your wife die there.
I didn't know what to do. I was in a state of shock.
You are an adult man and you don't know that a wife is there, an unconscious state, and you should just sit down there.
I know Maria
No
called
prudent
somebody
man
for
will
help.
do that.
I knew Maria called somebody for help and they'll be on their way. And I was so exhausted and tired to be thinking straight then.
Okay, so do you agree with the fact that no prudent man will sit down and see a wife in unconscious state and not take her to the hospital and just wait in an assumption that your daughter would have called someone for help?
My no prudent state in the man of my
No
age or
prudent
my,
man in the
no
right
prudent
state.
man in the right state of mind would have faced the same situation that I was in because he
So
was
no
in
other
the
prudent
state
man
of-
will ever face the situation. This is what you meant to say.
no prudent man who ever faces the situation will be subject to the same condition that I was. I believe so because I was in a state of shock to be comprehending anything then.
Anyone if you would see someone being attacked would be in shock condition, but that doesn't imply that someone would sit here and see that wife is dying.
I was extremely tired. You understand, I went for the checkup the very previous day and I was extremely tired and I fought off a man. And
Okay. So this is a story that you were tired and you saw that your wife is in unconscious state. That's why you waited for some other help. This is what your story is.
this is
Am
what
I right?
happened. This is
Okay.
what happened.
That's all for Jackson. Also, a few questions more for you. Why did not you tell it about the police about this third person?
They didn't ask me.
So they arrested you. They did not question you before.
No, they did not.
After that, why did not you told them?
I didn't get the chance to.
Did the whatever the intruder was there, the third person? Why did he came? Why do you think did he stole something? Did he make any robbery? What was his intention to interfere in your house?
I don't know because we caught him red-handed, and I don't think if at all he meant for a robbery, he would continue the same. Considering he knows somebody's awake and he knows somebody's aware of his presence there. So I don't know why he did it, but I would say the area is a robbery-prone area. So
Do you
I
have
understand.
do you have a problem with someone that you think would have committed this crime?
Robbery need not have a cause for doing that. It can be for monetary purpose solely.
Was the back door have a lock?
Yes, it did.
Was it locked on the day?
Yes, it did. It was all locked on every day.
It was locked on every day. Okay, that's it for you.
You have could you identify the person with whom,
Uh,
for the intruder?
Your Lordships, it was dark in the night, and
It was not dark in the night.
it was dark in the night, Your
It
Lordship.
was July month, 5:30 July,
Indeed, Your Lordship, but there were no
July.
windows to the room.
August. July what time? Plus,
Indeed, Your Lordship, there were no windows to the room.
all right. You said you grappled with him.
Yeah, indeed, Your Lordship.
After having grappled with him, you are not able to identify.
No, Your Lordship, it was dark in the room again.
Now you can't identify.
No, Your Lordships.
That's all.
Your Honor, just few more questions. 4 questions. Did you tell this about third person to your grandfather? To the grandfather of Ms. Maria Smith?
They already decided I was the criminal, and they were not ready to hear anything about from me.
So what happened after grandfather came? What happened after that?
I was just sitting there because he just went past me, ignoring my existence.
After also they came, you were still sitting there.
I was sitting there because I know she was taken care of because I saw Matthew and the neighbors taking her to the hospital.
Okay, so you're thinking someone else is taking care of your dead wife and you can still
I didn't
sit
know she was
and
dead.
see. Okay, so you thought she is unconscious, someone strangled her, she's still unconscious, right?
Indeed.
That's what. After that, what you did?
I was just sitting there.
Okay, so grandfather took the wife your wife's dead body, you were still sitting there.
Indeed.
And then what happened after that?
Given my state of, I thought somebody, if at all somebody is going to ask me about it, I tried talking to my grandfather, to Maria's grandfather. And yes, he was already determined that I was the criminal who could strangle his own wife. And I didn't know what to do. I was just sitting there. Yes, that explains it.
Okay. Then what happened after that? Like, did you went to hospital with your the
No, I
grandfather
did
of
not.
Maria's?
No, I
So
didn't.
what did you do?
The area was sealed and the IO officers asked me to please seat it there. They did not ask me for my
I think there
statements.
is a time difference between IO coming and them taking to the
Indeed,
hospital. So
indeed.
what is the time duration?
I'm not sure. I wasn't noticing the time exactly.
You can tell the approximate time.
I wasn't noticing the time. I was in a state of shock again.
So you did not went to the hospital. You still sat there.
Yes, because I knew there is no purpose for me to go to the hospital when I knew she was being
You
taken
would
care
be
of.
understanding more that what you think is correct, but you are not taking actions on it. Right.
Because
You
there has to
think that you cannot do something. That's why you're sitting there. Is it true to say that?
probably, yes. There is no effect possibly that I can go.
When the IO came, then what was your response?
I was just sitting there. He asked me to sit, not move, and he sealed the rooms, and he did not ask for my statements either.
Okay. He did not ask you statement.
No, he did not.
All right. That's all.
Your Honor, can I proceed for re-examination? Re-examination.
What is the ambiguity?
The clarification that we necessarily want is with respect to backdoor, and also we also wanted to know whether he knew that Rachel was dead or alive, in what kind of state she was. This is the two these are the two clarifications that we need. First clarification is with respect to the back door, with respect to the schematics of the house.
Category is stated very clearly. There is one balcony is different, back door is different. What more you want?
We wanted to clarify where the back door led to.
Where it led to?
Yes. Where did the back door lead to? You had mentioned that there's a balcony and then there's a back door, right? Where did this back door lead to?
It was just open ground.
It was just open ground.
It's all right. Any other witness? Any other witness?
Yes, Your Honor.
What witness you want?
We have two more witnesses.
Who are the witness? No, you not explain. Having put the accused in the box and examined as first.
Yeah.
You will test the relevancy of the other witness.
The second witness is Dr. Bernes, the psychiatrist that used to treat Mr. Jackson.
About his mental illness something. And he has in fact grappled with the person who entered, which means he was aware of some person attacking his wife.
Yes, we want to establish that when he is out of his episodes of hallucination, he is in a stable mind.
He never said that. Never said that he was taking treatment. He was taking treatment only for addiction. He was never taking treatment for any mental illness. It is not your case. Nowhere you have set up a case that you are having the thing. What did he say? If you put him in the witness box, 100 times he asked you, are you going to put him in the witness box? After having put him in the witness box, he never opened his mouth to say, now what is the doctor going to say? What do you want? What facts you want the doctor to say? That he was in a state of insanity.
No. He was in the perfect state. A prudent mind. He was not in a state where he was under substance abuse.
Very good. That's exactly, that fact has been proved. See, please, all of us are supposed to be in proper state. Proof of fact is required only we are in an improper state. Please understand.
Right.
You and I today are in a proper state of mind. Suppose you and I are mad, they are special state to be proved. So you presume, we thought that he is going to say that he was thing, but he said that nothing, he's perfectly thing. So what is the doctor going to,
Let's you take the defense under section
84
or section 23. You necessitate the exam any doctor to show that he is mentally fit.
all of us are mentally fit. Nobody proves Nobody puts a witness in the box to prove his mental defect.
Not be proved.
For healthy, all of us are presumed to be healthy. Unless there is illness, that has to be proved.
Yes, Your Honor.
So disallowed.
Yes, Your Honor.
Next question.
We have one more witness.
What is the relevancy?
We need to establish that that essentially was a criminal activity by way of defense witness 4, that is Mr. Arab, who's their neighbor.
What?
Mr. Arab is their neighbor.
If you have anything that
Mr. Arab is essentially, yes.
correct.
Who has also said that observation was there.
Yes.
Have you put any?
Your Honor, it is also with respect to establishing the fact that there was presence of CCTV footage.
You never asked the IO. You never asked the IO. But the first thing you ask is, what happened to CCTV area? Did you seize them? How many crimes take place? Your crime record is what? How many FIRs registered on murder? Nothing. You just allow the IO to go like that, and you want this witness to what fact? Yes, what fact?
The fact that we're essentially trying to get out for Mr. Arab is the fact that there's high criminal activity
Yes.
and it was
And
under
for
CCTV
men,
surveillance.
there is a lot of criminal activities in it.
And also another important factor is with respect to the outside relationship between Rachel and Jackson.
And
Rachel and Jackson. The
And?
relationship between Rachel and Jackson.
strained or good relationship.
That we want to establish that it was a good relationship.
He himself has stated, I love my wife like anything. I've never nothing. He said that he's everything, and nobody said there's a strained relationship.
Your Honor, this is necessarily for corroboration.
What?
Corroboration.
We'll accept it.
Uh,
Anyway, you put the witness.
We just want to point out,
yes, Your Honor.
perhaps in cross-examining the IO, after meeting the bus,
You're trying
and
to
now try to kill it. This will not be allowed in the real court of law. Right. Now, you want to examine one of the residents so that there was a very cordial relationship.
Yes.
That is, to contradict the evidence of PW2, who has said that
And PW1 Winston Churchill. Yes. Yes.
Not that to corroborate the evidence of your witness that is accused PW,
But more.
evidence of prosecution.
Yes.
please put it.
Arav.
Can I begin?
The presence of Almighty God. The evidence which I shall give before this court shall be the truth, the whole truth, and nothing but the truth.
Good evening, sir. Please state your. Good evening, sir. Please state your name, age, and address for the record of the court.
Yeah, I'm Arav Ayush. I'm 30 years old. I'm residing in number 116, First Cross Street, Calder.
Can you please explain the relationship of what is your relationship with respect to Rachel and Jackson?
Yeah, I came to know about Jackson around 5 years back. He used to have, he still has his washing machine repair shop near my house. And around around January of this year, he moved along with his family near my residence. I just know him just as a neighbor.
Have you ever noticed the relationship between Rachel and Jackson?
Yeah, they had a healthy relationship. They used to go outside to parks, theaters, along with his wife and as well as child. They used to live a contentful and pleasantful life.
How familiar are you with your neighborhood?
Yeah, I'm very much familiar with it. I have been living there for the past 20 years. It's not a safe place to reside to actually. There's high crime rate in the spot. There's increased amounts of robbery, theft, snatching, and all those sort of crimes. I think this is the reason why the rents are so low in this region.
What do you say about the security of your locality?
Yeah, it's not, as I already stated, it's not that secure. In order to ensure security, many people will install CCTV cameras, and even I have guard dogs in my house. Even Jackson and Rachel have CCTV in their house. I have noticed.
Can you please explain the exact location of your house from Rachel and Jackson's house?
Yeah, my house is located in the opposite lane of Rachel and Jackson's house.
Solid. Open for cross.
The council seeks permission to proceed with the cross-examination of Mr. Arav. Much obliged, Your Lordship. Mr. Arav, so can you explain what happened on 2nd July 2020?
Never said anything about 2nd July. Will you just shut up?
So I'm asking if he can say.
Cross-examination, you should learn what not to ask them, what to ask them. Never came to 2nd July.
Okay.
I'm a neighbor. I live in the opposite state. And I know this family is very good. He has seen him going to park and things. You ask him, have you not fought with your wife at all? These are the questions, because anybody who goes to the park doesn't mean he's not fight with his wife.
Yes, Your
That's
Honor.
part of going to the park and having fights. You put those questions.
He has spoken something about CCTV camera and other things. You see in 161 statement whether he has said anything about that.
No,
He's a
that's
different-
nothing.
So, put that question. Have you said this to the IO when IO examined? If he says yes or no, you can confront that. You have not said that, it can improve.
Okay. Understood. So, Mr. Arav, did you ever talk? Previous state. So, Mr. Arav, did you ever talk about the CCTV footage to the IO?
It was not investigated by the IO.
Why a statement? Want to contradict a witness?
My lords, the statements were provided as aid memo. I haven't spoken with the.
Sorry?
I haven't actually spoken with the IO. The statements are provided as aid memo.
So this statement, what is now being relayed by the prosecution, was not your statement, according to you. Police themselves have written it.
No.
EW4, statement of Mr. Arav, 830, son of Ayush, residing in 116 Park Street, Gowri.
My lords, even the heading mentions it as aid memo. It's just for the assistance of the defense.
Okay.
It's not an actual 161 statement.
There's no previous statement for him. There's a defense witness, no.
Yes, Your Honor.
See, defense witness will have a previous statement where a particular witness has been examined by the police and the statement filed, but he's not examined in the box. Supposing Arav was a list of witnesses, his one statement is there. But where prosecutor decides not to examine Arav, defense wants to use him as a defense witness, then there's a previous statement. So what is his right? There's no previous statement. Now, what is it that now yours is an apartment, is it not? Where the incident took place.
Floor of the house.
Second floor of independent bungalow.
House owner is
House-
not.
House owner on the first floor. And we are asking you, prosecution,
Yes, Your Honor.
don't ask Arav. Arav is a neighbor.
Yes, Your Honor.
You be thorough with your facts.
Yes, Your Honor. Could you please repeat the question?
The incident.
With an independent house or an apartment having side.
It's a two-story building. If Your Lordship allows the council permission to proceed. Much obliged, Lordship. So, Mr. Arav, can you, as you said before that they have a good relationship, how do you say that they have a good relationship? Have you seen it closely?
Yeah. To be frank, I'm not that close with Jackson and Rachel. Whenever I have seen them in the public, they were in good terms, and I have spoke with them occasionally at that time.
So, is it true to say that you don't know you don't know both of them closely?
Yeah, I just had a casual relationship, not a close one.
That's all.
Thank you.
What is the other witness next? Start the argument.
Your Lordship, the council seeks permission of 1 minute to wrap up the closing statement, to make the closing statement.
See, it is they who should start. Because theirs was the last witness.
Yes, Your Honor.
You need not have to start. No, let this go. Prepare yourself and start. You start. You only put the witness, no? Final witness was the last witness. Start. You would have prepared for rebuttal. All right, I'll leave it. Okay.
Hello. The council seeks permission to proceed with the closing statement. Much obliged, Lordship. Your Lordship, in the particular case, if we go by the by the proceedings set by the Supreme Court, it has said that in circumstantial evidences, in the cases of circumstantial evidences, the prosecution has the burden of proof beyond reasonable doubt, and also prove there is no other hypothesis that should be present in the particular case, so that the accused can be prosecuted. Your Lordship, no, Your Honors. Since the prosecution came up with defense came up with a hypothesis. Yes, Your Honors. Your Honors, in this particular case, the Mr. Jackson himself has admitted the fact. No, Your Honor.
The case of direct evidence.
Yes, Your Honor.
PW2 is there.
Yes, Your Honor.
Standard of proof for a direct evidence is different from circumstantial. Golden rule of circumstantial evidence. Don't have to waste your time on that.
Okay.
Your
Honor, in this particular case, that the prosecution wants to prove it by following the ingredients of the murder and the attempt of murder. First, moving by the charge of 109, that is attempt to murder, its ingredient says that there should be a mens rea, actus reus, and a bodily injury that could lead to the death of the person. In this particular case, since Maria Smith witnessed Mr. Jackson strangulating her own mother, he attempted to murder Maria Smith at the same time. That proves that there was a mens rea from Jackson to attack Mrs. Maria Smith. Secondly, again in the actus reus, his attempt would come under actus reus, and the act which he took comes under the injury form. That means the ingredients of the attempt to murder 109 is fulfilled, and therefore the charge of 109 will be levied on Mr. Jackson. Proceeding with the main charge, that is 103, murder, it again has few essentials and few ingredients that need to be fulfilled from the side of the prosecution. Yes, Your Honor. Your Honor, as per the section 109, it does not say that there should be a bodily injury as per. Correct. Yes, Your Honor. True. Your Honor, in this particular case, since there was no other witnesses present there, and since the sole eyewitness was there, and there is a reason to attack Mrs. Maria Smith, the mens rea itself proved that there would have been attempt to murder. Yes, Your Lordship, there is no other witnesses or other evidences that does corroborate with it. But at the same time, as per the statement of Miss Mary Smith, she says that after attempting to murder her, he went and sat down on the chair. When the grandfather came, he saw him sitting at the seat there. Yes. Uh, Yes, Your Honors, that is one of the reason. But at the same time, when the prosecution is proving that there was a murder, at the same time he was waiting not to open the door. Since the grandfather came at the same moment, he couldn't attempt the attempt of murder again. And since there is no other evidences present there except Maria Smith, that is the case of the prosecution.
And or fall on the evidence of pedophilia.
Yes.
109 is not.
Yes, yes, Your
If you believe PW2, 109 is. Don't believe PW2, 109. Is it not?
Your Honor, that is one of the case, but at the same time, for corroborating of that, the only evidence the prosecution have is then when the grandfather came, he saw they saw. Yes, yes, Your Lordship, except that there is no such other evidences that is present there. Yes, Your Honor. Yes, Your Honor. Proceeding with the charge of murder, again the ingredients of mens rea, actus reus, and the injury that causes to death has to be established from the prosecution side. Your Honor, this particular case, Mr. Jackson had always a fight with Rachel and also had argument as we previously said. At the same time, since he was addicted to drugs and all, this was one of the issue between both of them, and that lead to arguments all over that. So that do lead to a presumption that they might have an argument, and except that no one was present at that particular stance, another hypothesis cannot be created. And the only person that is there is Mr. Jackson. Therefore, he could be that he should be prosecuted as the accused in this case. Also, Your Lordship, citing one case in the precedent said.
The law.
Okay.
Criminal law stands or falls on its own weight on evidence. It is entirely based on evidence based. So put all judgments in Bay of Bengal. Just throw it in Bay of Bengal, argue on fact.
Okay, Your Lordship. Your Lordship, in this particular case, since there was no other entrances that was present in the room, Your Lordship, just to corroborate, when the Mr. Jackson came on the stand, he said that the back door are always locked. That is one of his statements. At the same time, he said that someone entered through the back door. When the back door is itself locked, how can someone enter through the back door? Again, he made a statement once that the back door is in the back. Then in the second statement, he made that the back door opens through the ground. Now, there is a back door who does not have any stairs, who doesn't have anything, and it just opened to the ground. This statement itself does not make sense, and it's proof that he is lying on the head of the in the court, and that proves that there is no chance of third person to entering into the room. So the two person left is here is that Mr. Accused, Mr. Jackson, and second is Maria Smith. And Maria Smith itself said that he saw Mr. Jackson strangulating her mother. Secondly, there is a claim that have been made by the defense that she had made a statement that a man resembles like her father. She in her statement said that she saw a man from sideway. Therefore, she did not directly make the statement that it was my father. When he came over her and saw that it was him who was strangulating her mother, he confirmed that it was my father. Even in a statement, she mentioned to his grandmother, that it was my father who was strangulating her. So the incident which she told is particularly to what she saw and to what she finally saw. That was a sequence of a statement.
And that statement has been proved. It has been proved. Please understand. Proof of fact is one thing. Proof of statement is another thing. The fact that Maria told the police that a man strangled my mother has been proved through the IO It was asked and it was proved. Even though Maria stated that she doesn't remember what she said, but that statement is proved, not fact. How do you reconcile this contradiction? The witness box, he says, so the father was strangled. The police, he said, a man. How do you reconcile this?
Yes, correct, Your Lordship. She said that. That's what I'm saying. When she saw him strangulating her mother, she herself admitted that she saw him from sideways. Then only she took the phone and called her grandfather. Then after, when he came over her, she saw that it was his father. Then only she told her it was my father who was strangulating my mother. So her statement is itself not credible. Thank you, Your Lordship. Proceeding with the fact of mens rea. Proceeding with the facts of the mens rea, it says that that Mr. Jackson did not even, if he did not even have a mens rea to kill his wife, he did not even take her to the hospital. That itself creates a mens rea that he wanted his. Yes, Your Lordship.
Incriminating to the accused.
Yes, Your Lordship.
You almost come. That is, according to you, fellow was simply sitting when his wife was something. Which provision of Indian Ordinance Act would you present to service for us to?
Yes, Your Lordship, section 7. I'll just refer to it. You'll Your Lordship, referring to section 5 and 6 of, yes, Your Lordship, section or subsequent conduct. Conduct was that he was sitting there while his wife was dying.
Conduct of
It is relevant.
under section 8 only it is relevant.
Yes, Your Lordship.
Watching when his wife was reading incriminating conduct.
Yes, Your Lordship.
I was in a state of shock. What is your answer for?
Your Lordship, the answer for it, no prudent man, while his wife will be dying, will be sitting there and waiting for some help. Yes, Your Lordship, the answer is there. When he saw someone. Yes, Your Lordship. Your Lordship, if he would have been a shock when the grandfather and all would have come there, he would have accompanied them at least to the hospital. At least.
That is also a conduct.
Yes, Your Lordship.
The shock would have gone after the case.
Yes, Your Lordship.
I was continuously shocked.
Yes, Your Lordship. Even he says that he fought with the man, then he got tired and he sat down and see his wife dying. That is also a conduct that how can you fight with a man and then got tired and just sit there and watching your wife die? That does not even, cannot make a case of even assumption that this could have been happened. So even all this prove that there was a mens rea, even it get proved under section 6 of BSA. Yes, Your Honor.
Another point is also there. Conduct of PW2 in up a grandfather is also relevant under section 8.
Yes, Your Honor. Yes.
He doesn't sit in the chair and watch. A small girl, 13-year-old girl, is able to ring up her grandfather. This is a conduct relevant under section 8. Conduct is not only of the accused. Conduct of witnesses are also relevant under section 6. I'm sorry, not 8, old 8, present 6.
Yes, Your Honor, it is.
So when the small child could call the grandfather, what this fellow is sitting and watching, is an argument which we expect from you.
Yes, Your Honor. A normal person cannot sit there and watch, and it is even in the section 6 of BSc that says that subsequent conduct of a witness or of an accused is relevant to the case of the prosecution. Yes, Your Lordship. As proved before, since there was no interference of a third party, since there is no chance of third party entering, the accused, Mr. Jackson, himself has been made a lot of contradicting statement that the back door is here, the back door is there. At the same time, he knew that his wife is dying and is sitting and watching that. His own daughter, that is 13-year-old, is calling the people and he's still not making effort. even after all that, he did not came out of the shock and he did not even help them to go to the hospital to check on his wife. So that proves that there was a mens rea from the side of Mr. Jackson, and that proves the case of the prosecution that he was the one who killed his wife. And that is all the case from the prosecution side. Yes, Your Honor.
What about section 109 of Evidence Act? Burden of proving 3 persons were in that flat. Did not. Maria, one died. Daughter, this fellow is alive. Daughter has got into the witness box. This fellow has also got into the witness box. All right.
Yes, Your Honor.
So he's trying to prove fact, especially within knowledge. Within his knowledge, this knowledge says that yes, some fellow jumped from somewhere, committed the thing. What is the standard of proof required to prove a fact in a criminal? In any case, what is the standard of proof that is required? Standard of proof that is required to prove a fact. Standard of proof. And please be very careful. Where will you get it? What is the quantum of proof? What is the quality of proof? Go to the word proved in Evidence Act.
Here is question what he's saying.
Prosecution, go
Yes,
to
Your
the
Honor.
word proved in the BSA, new BSA.
Yes, Your Honor.
2J.
2J. Yes, Your
Read,
Yes, Your Honor.
slowly read with all the commas and things. Read.
A fact is said to be proved when,
Comma,
after considering the matters before it,
comma.
okay.
Just comma, I'll just get irritated.
A fact is said to be proved when
Fact is said to be proved. What is the fact, first of all?
that a person came inside and
A person came in. No. The person killed. What's the fact that you want to prove?
that Mr. Jackson killed his wife.
All right. You want to satisfy us, both of us, that Jackson killed his wife. So that is the fact.
Yes,
All
yes.
right. So when it is proved,
Then, comma, after considering the matters before it,
after considering the matters before means what? After considering the circumstances of the case. It's not.
yes, Your Honor. Comma, the court either believes it to exist, comma, or consider its existence so probable that a prudent man out, comma, under the circumstances of the particular case, comma, to act upon the supposition that it exists.
So we are prudent men.
Yes.
We judges are prudent men. So want us to believe that Jackson killed his wife.
Yes, Your
All
Honor.
right. From the matters before which you produced, what are the matters? Second floor house, door locked, back door open, 3 persons, deceased, husband, 13-year-old girl. And so from all these proved facts, what is the prudent man's inference? So probable that a prudent man, what under the circumstance of the particular case, act upon something that exists.
Yes,
That's
Your
all
Honor.
it's your work.
Understood.
You don't have to go to this judgment, Supreme Court, this one. Put everything in Bay of Bengal. Just throw it.
Thank you so much,
Go
Lord.
by fundamental criminal law. Just go on evidence, on that.
Yes,
Well,
Your
they
Honor.
will have to prove, disprove. They will say that, okay, these facts are not being proved. They'll use the same section to say that it is not being proved. So we'll have to hear them that.
Yes, Your Lordship. Understood. Should I go with this this to explain my case? Yes, Your Lordship. As said in the definition, it's itself said that when we're talking about Mr. Jackson killing his wife, there is no third person who could have entered in the house or would have committed the crime. As per the previous statement made, that since the back door was closed, even if the back door was there and not in the balcony, some other place, and it is a second floor building and it's an open ground, no person could have entered through it. So it simply proved that only 3 persons were present in the room, and that was Mr. Accused, Ms. Jackson, and second was Maria Smith. So when the story that is made by the Jackson doesn't comply with his own statement and the situations that have been given, therefore he is the one person who had the mens rea, because even after seeing his wife being dying there under section 6 of BSA, his subsequent conduct should be that he should take her to the hospital, which he did not. Even after that, when he should have come out of the his shock, when people would have arrived, he still tell that I was in shock and he did not accompany anyone to the hospital. That implies that there was a mens rea from his side that his wife should die. So that is the case from the prosecution side.
PW2 is none other than his own daughter.
Daughter. Why would it?
Why should he false testimony against his father? First put a PW2 like your father. Father did not get you a balloon, did not get you chocolate. So you are angry with father. So you gave false evidence against your father. They never put any suggestion to PW2. You should exploit that and tell us that PW2 is a star witness. What is the motive for PW2 to speak lies against their own father?
Yes, yes, Your Lordship.
That's all. All right, tell us. What is the ingredient for
Murder.
You say that man has committed. So there is another than this man who could have done it. First of all, have you proved that it is a murder?
Yes, Your Lordship, it's a murder. Since
The possibility is also not there in your thing. And injuries are the regular course of events would have caused death. The ingredients of murder is there, no? Murder. Death, okay. Culpable homicide could also be culpable homicide, not amounting.
no, Your Lordship. Since it were culpable homicide, there should be no intention. Whereas in the yes, Your Lordship.
Natural death or unnatural death? What is the evidence you have faced?
Your Lordship, as a postmortem have been provided, at the same time, the doctor, as postmortem doctor came here and gave a statement about the injuries. At the same time, if I refer to the question that how is it murder?
It's not even admissible. Person was on a piece of document, but that document called as postmortem report not carry any authenticity.
Doesn't even bear a signature.
Yes, Your Lordship, that is the one of the loophole from the prosecution side, but that does not give the defense an loophole to say that Mr. Jackson was not one of the person who killed him, because then there is no other person present out to make that other person would have killed it. So it does imply that Mr. Jackson is the accused. We do agree with you that since the postmortem report did have some of the loophole, that is a signature, and we do accept it.
Fine. We appreciate the prosecution for fairly accepting the thing. The only thing you can stump them by saying, even according to them, it was a murder, but by third party. It is not their case that they didn't take use of that post-mortem report thing to say, no, it's a natural death. If they had taken a stand, it's a natural death, your case would have gone.
Yes, Your Lordship.
They did the case for you by bringing in an intruder who committed the murder.
Yes, Your Lordship.
That's why you 100 times asking them what do you want to put the witness.
Prove them by postmortem. Yes, Your Lordship.
Right, that's all. Yes, ready. Now it's up to you.
Thank you, Your Lordship.
Your Honor, the counsel seeks permission to move on with the closing arguments based on section 257 of the BNSS. The defense counsel humbly submits that the prosecution has failed absolutely in proving that the case beyond reasonable doubt. Now, the key argument of the defense is that the prosecution has necessarily failed in proving the elements of murder, that is mens rea and actus reus, and additionally the attempt of murder, which the elements of which are intention or knowledge, and or an overt act that is more than mere preparation. To substantiate our arguments, we would like to go through the statements that were made by during the cross-examination and the chief examination. Prosecution witness 1, that was Mr. Winston Churchill, had stated that his house is 15 to 20 minutes away from Rachel and Jackson's house. And he said that he had reached at 6:30, which is
Okay, depends. We disbelieve PW1. Go ahead, come to PW2.
Maria. Essentially, the prosecution, it's very clear that they're trying to build the case around the sole eyewitness, that is Miss Maria Smith.
Why should Maria Smith? What a question. Your own thought.
Because during her examination itself, Miss Maria Smith had stated that her relationship, the relationship with between her father and mother was not great, and definitely it is definitely plausible for us to assume that her statement came from a place of affinity bias.
Affinity.
We had she had also told during her examination that she's more closer to her mother, and that she
She never said. Closer to mother, not
she
those two never think that's what.
she Your Honor, she had also suggested that he was taking treatments, etc., and she had suggested that he was taking treatments, etc. So it is possible for us to also conclude that definitely, and any daughter would obviously not sort of tolerate the fact that her father is abusing or violent towards her mother, or has frequent fights. So she is prudent enough to understand that her dad is necessarily a person who is a violent person, or
It's always the other way around, no?
so definitely there would be.
You love your father more than your mother. Tell me not. My daughter loves me like this. Between my mother and things, you will only come with me. That's not all daughters are. So it's actually against the natural law. Because Oedipus complex.
Your Honor.
You can put it as an affinity by. All right. All right. Proceed.
She had also stated that her grandfather had arrived within 10 minutes. 10 minutes. And you had said Winston Churchill chuck it in the Bay of Bengal, so I'm not going to go down that lane. She said,
Your case, it's also not your case that somebody came through the front door. So, so Winston Churchill had all come through the front door.
yes.
It's locked at all.
The defense would like to point out that she had woken up from sleep. She is essentially a little disoriented. She had also stated that in the bedroom it was dark, and only there was a night lamp. So, and she also said that she did first when she was asked, she had stated that someone was strangulating her.
Correct.
Then she went back and forth with respect to that statement. I hope Your Honor trying to
You remember that?
right. So, corroborating this situation, we could definitely come to the conclusion that when Jackson was trying to actually help her out, she misunderstood that it was her father. And this could be because it was dark, she was disoriented, and like I stated before, definitely due to affinity bias. And therefore, she misunderstood that he was trying to strangulate her, because it was not even seen from the front, the seen from the side.
And thereafter she went and tapped in the chair. The same person was there when the people who want to enter,
Sitting in the chair. It is not getting the chair down. She included that in the chair and ran away.
No, at the same time, if Maria was coming in, it was possible for Jackson to run away as well. But he sat on the chair. And even the accused, he had essentially, can I have the permission to establish our chain of events? So, Mr. Jackson was sleeping on the bed. He heard noises. He woke up. He saw that his wife was being strangulated by a man. They had a scuffle, a struggle between, he's trying to save the man. Prevent the man from attacking, from strangulating Mrs. Rachel. Man runs away. He knows that the 13-year-old daughter is also present in the house. So the chances that him running back of the intruder is also, and we had also established it's a area of high criminal activity. So there could be chances that another intruder might come in. The scuffle happened, he left. He continued to sit beside her, and he was trying to understand what the situation was going on. And then further, Maria comes in. As a father, definitely it would be his first instinct to see that whether she's okay or not. He turned, Maria's okay or not. He turned towards her. Because she was coming from the back and she saw that, like I had established before, she misunderstood the fact. She assumed that he was coming with the gesture of consolation, like this. But she thought that he was trying to strangulate her because she had already assumed that he was using strangulation. He was trying to strangulate Rachel. So there should be a probability that he's going to strangulate her as well. And she got scared. She moved back. He went and sat on the chair quietly because he understood that she pushed him, and she pushed him, and then he went sat on the chair, saying that, thinking that if he goes for
his evidence, he did not say that she pushed him. No, you put him in the witness box. Whereas Maria only says when he tried to tell me, I pushed him. Says Maria says when I was trying to call grandfather, this man came. But your evidence must your client must have stated no. I went near to hug my daughter.
That's what accused had specifically used this word, that I had turned harshly. When I turned towards her, she thought that I was going to attack her. She got scared. She pushed me, and then I did not take further steps because he realized that she was in utter state of shock. And the Winston Churchill comes in.
The group comes.
Yeah, group comes. So this is our chain of events.
All this labyrinth court, juniors will pull and something. Very good. Your idea of thought will be one thing. Juniors will be thinking all this comedy will take place from the bench. We will see the comedy and enjoy. Okay.
Your Honor, we would like to point out the lapses in the investigation report and with respect to the forensic evidences. Can I move on to that? Okay. So the investigation officer was oscillating between the fact that whether the back door was broken or not. Clearly in the report, it has been said that the back door was open, but in a statement, he had said that the back door was not open. That is one major lapse on his part.
That door.
Your Honor, he specifically stated that the lock of the back door was open. The lock is different from the door itself. So how can he handle? I'm so sorry. Yeah, it is the latch itself and not the back door itself. Handle.
Advantages. Door breaking is advantages or handle breaking is advantages from accused point of view.
The door.
Why did you exploit of that?
We did, Your Honor. That's what we were trying to get from the investigation officer as well, which he did not. He oscillated between his statements.
Door broken is advantages. So somebody broke the door.
Door and came. Yes.
So the back door was locked. Somebody broke the door and came.
Yes. Yes, Your Honor.
Okay. Entry point. How you can put one person, you put one person to the car.
Your Honor, what the accused was trying to say was that there is, Your Honor, I would like to clarify something. There is a back door. The accused had stated that what the accused essentially meant was it was leading to a bare ground. Would definitely in a two-floor story house, there'll definitely not be a back door and nothing behind it.
That's why you're evidence. So that's why the inspector was time and again saying, no, there's a balcony. This door open to the. That would have been a better case for you. Somebody jumping into the balcony, breaking open the door, including would have been a better case for you.
Your Honor, he also said that there was that he negated the fact that there was an intruder because he could have used a rope or ladder. But it is the investigation officer. He negated the entrance of another person. Yes, Your Honor.
That way itself, on investigating your culpability. Definitely like that. Now you could have easily the theory that back door was broken because somebody could stand in the balcony break the brother. One can't hang and break, no.
Your Honor, what you're trying to clarify is that the back door was leading to the bare ground next to the house. That will, no, there's a flight of stairs.
Like a painter, this can have a so other continue to break. Don't come with Saram and all.
Your Honor, why would there be a back door if there is nothing to go down? No, that's what we're saying. We are trying to clarify that there was essentially a staircase that led to the bare ground. My question was very simple. Where did it lead to? So the accused said that it was leading to a bare ground. Leading to a bare ground. Your Honor, there.
House, yeah.
He did not say
Your
that
house.
the stairs came to go down.
That's why he was saying from the beginning, you are this house, you tell about the topography of the house, geography, who thinks.
Calling him and so not his case. He was able to understand what happened on the case. And he was able to give evidence today and also with the cross-examination. And there is no evidence to show that. Subsequent to November 23, he was taking any treatment. Even before or after, or on the date of he said, so that's different. Only difference available to you. Some input that possible.
Yes.
Yes. There must be some entry point for the input to commit this offense and go. For that, so there was broken inside. But I did not investigate anything further because it has no significance in the investigation. It is his answer, specific answer. I did not investigate much about the broken because it has no significance. But you said that the door, but he entered and gone out. For that, he says that when the door is open, it goes in. So,
Your Honor, Your Honor, what I would like.
Theory would have been good to you.
In terms of case, that side also, any of the prosecutors, and your witness also did not say.
Your Honor, there are different ways by which people answer a question. My question was very simple. So you would have probably missed the fact that there was presence of staircase. Well answered, because my question was very simple. Yeah, where was it leading to?
Your question was?
It was very straightforward. Where did it lead to? He said that it led.
How do you read the father? So how to read the father? By staircase or by helicopter or by lift or something? Father.
Yeah.
All right.
That,
Particular question. Somebody else said, IO would have said something else. The occupant of the house said something.
So, all right, now we'll test your theory. Your theory is a man came through the back door, not going to the balcony from some staircase or either parachuting himself to the back door, opening, coming, murdering, running away for no reason at all. You did not even say that he had sex with my wife, tried to rape her, nothing like that. Robbery, we lost some jewelry, things and all, nothing like that. That session also you're not. Yes, you were taking things and going. Nothing. Or if you're not even stated the theory, the very death, as my brother pointed out, if you have been prosecuted to prove that it was
Your Honor, first, what I would like to clarify again is that they are a family that is facing extreme financial crisis. So the chances of them having something valuable that can be taken by they are Christian.
Good answer. Excellent answer. Super. Excellent.
So, Your Honor, with respect to the, can we move on to the autopsy report? With respect to the autopsy report, there was no signature. There was no time of death, no cause of death. And also, he mentioned about rigor mortis. So, ideally, if rigor mortis,
He put the effort of the report in there. Hey, my brother said you are not even proved the thing. If not for you strangling, you would have just given okay. That has not been.
Your Honor, also with respect to, I think your bench has had also put in this question forward, whether Maria was taken for any sort of medical examination as well, which has not been done. So that is also a major lapse on the side of the investigation officer.
Your thing. But simply sitting and watching when a small girl is able to ring up the father and come. So just sitting there and watching your wife.
Your Honor, the sole witness, that is Maria, had said that the help came within 10 minutes. 10 minutes is of when you're getting up from your bed and you're seeing that your wife is getting strangulated. What the defense would like to argue is that 10 minutes is a prudent time for a person to remain in shock.
I mean, even after 10 minutes, you continue to be in shock because the body has been taken. You simply sitting till the police arrive. Police has come very late. You are able to fight with the intruder, and you are saying that you did not see the face of the intruder appears very thick. See, July month, in Madras, July month, it's rating. 5:30, 5:45, whatever the incident has taken. You grappled with the fact, and you say that I can't identify it.
Your Honor, what I would
Satisfy them, otherwise juniors will not will create problem for you in future. That's the first one. Client சொல்றாங்க நான் எவ்வளவு பேசி பார்த்தேன் எங்க கேட்கல ஃபீஸ் கொடுக்காதேன்னுவாங்க அதனால
Your Honor, what the defense would like to clarify again is that through the statements of Maria, Winston Churchill, definitely the fact that Winston Churchill's sort of adverse attitude towards Jackson has been established. So he was not even allowed to be part of the process where they could take her to the hospital or anything, because he was not even allowed, because the minute they came, they had assumed that he was the one who tried to strangulate her, and that it was necessarily substantiated by the sole eyewitness, that is Maria Smith as well. So he was not given as necessarily an opportunity to take care of his wife. So he had to continue to sit there. This is what we are putting.
all. Lastly, what is thing?
And also another thing that I would like to clarify, that in Cardiff, it was necessarily winter season. So it's
Where would a Cardiff?
Cardiff. It is winter season, so even the visibility is quite less.
Visibility, ma, what grasping for the body visibility. So it's close contact in there.
Your Honor, he had just woken up from sleep, right? He would be in that disoriented state of mind, and then he also tried to grapple and his wife is dying on the side. He has a 13-year-old daughter. So all of this it is not necessary that a person at that point in time would be able to identify the intruder, is what we are trying to establish. We would like to go towards the end of our argument. We would like to go to the end of our argument.
That's all.
Yeah. So so what we're trying to establish essentially is that the prosecution failed to prove beyond all reasonable doubt that the fact that Jackson had mens rea and actus reus to murder Rachel, and he also did not have an intention or knowledge for the attempt of murder of his child, Maria Smith. We would like to move on to the prayer.
Yes, let me do so.
Prayer.
Prayer, acquittal prayer, conviction prayer. He'll ask for conviction.
Do you have any physical homework on citation?
Yes.
Any identical case you just circulate.
Correct.
That any similar or almost similar?
On your side?
Even from Ratana in medical report, the other witnesses, eyewitness, sole eyewitnesses. Yes.
Yeah, it's so like relation. It is not the quantity of it, it's the quality.
Yes, sir, also. Page number 13. Para number 13. So that was taken care of.
Even if your medical report does not support, I used to say, sir, this is sufficient.
Medical witness, see, if the even the medical witness doesn't support the case, eyewitness support. Even if there's a contradiction between eyewitness and a medical witness, eyewitness requires as a better thing than medical witness. Medical witness is only opinion witness.
Yes.
Eyewitness is into the fact. Of course, only when the contradiction is so irreconcilable. For example, if the eyewitness says that he saw the accused hacking, medical witness says that the body shows bullet injuries, then you can't reconcile between hacking and bullet injuries. So you must go by medical opinion.
Sure, I got the case. Case number 12. The case, seventh para. Should I read it for you?
Yeah, please.
It is sound and well-established rule of law that the court is concerned with the quality and not with the quantity of the evidence necessary for proving a fact. It may convict or acquit based on a sole witness.
Thank you, Your Lordships. What we have just witnessed was nothing short of spectacular. I would like to take a moment to just express my gratitude and sincere gratitude to our esteemed judges panel, Honorable Mr. Justice P. N. Prakash and Honorable Dr. Justice G. Jayachandran. Your dedication to guiding and mentoring our participants through your insightful observation have undoubtedly enriched the experience and also learning experience for all of us. Thank you, Your Lordships. The valedictory will be resumed soon.
Sir, you cannot do that actually. You'll end up drawing the both.
எடுத்துலாம் கொடுங்க. நத்திங் ஈஸியா.
இல்ல சார், அது பேலன்ஸா? We request everyone to rise up to pay your respects to the arriving dignitaries. We request everyone to be seated. Respected Chief Guest, Honorable Dr. Justice G. Jayachandran, Judge of the High Court of Judicature of Madras, Honorable Justice P.N. Prakash, retired Judge of the High Court of Judicature at Madras, currently serving as Special Public Prosecutor, National Investigation Agency, Honorable Vice Chancellor, Colonel Professor Dr. N.S. SANTHOSH Kumar, Mr. Kalyan Jabak, Senior Partner and Head of Dispute Resolution, Surana and Surana International Attorneys, distinguished dignitaries on and off the dais, faculty members, esteemed participants and students, pleasant evening wishes to everyone. It is with great enthusiasm and anticipation that we gather today at this prestigious forum where the rigor of law meets the passion of advocacy. On behalf of the Tamil Nadu Dr. Ambedkar Law University, it is our distinct honor to welcome you all to the Surana and Surana School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University National Trial Advocacy Moot Court Competition 2024. In the words of Aristotle, the law is reason free from passion. Yet today, we shall witness the harmonious blend of reason and passion as intellect challenges intellect and advocacy shines the brightest. I, Ashwath Dinakaran, alongside my co-MC Monica, take immense pride in being your host for this significant occasion.
To commence our proceedings with sanctity and pride befitting this occasion, we shall now pay homage to our roots with Tamil Thai Vartha, performed by Moot Court Association Choir. I kindly request everyone to stand in reference to honor our heritage culture.
சீராரும் வதனமென திகழ்பரத தண்டமிதில் தெக்கணமும் அதில் சிறந்த திராவிடன திருநாடும் தக்க சிறு பிறை நுதரும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிலமை திறம் வியந்து செயல் மறந்து வாழ்த்ததுமே வாழ்த்ததுமே வாழ்த்ததுமே. Request everyone to be seated. As we embark on this intellectual odyssey, it is my privilege to introduce a leader whose vision and dedication have significantly shaped our institution's academic landscape. It is with great honor that I invite to the podium Dr. Ranjit Uman Abraham, Director of VBA LLB Honors UG course and Head of the Department of Cyber Law, to deliver the welcome address.
Good evening, dignitaries on the dais, off the dais. It instills great privilege on me to give this welcome address on this very auspicious day, where we have just completed the finals of the National Trial Advocacy Moot Court Competition, which was conducted by Surana and Tamil Nadu Dr. Ambedkar Law University. And this happens to be the first National Trial Advocacy Moot Court Competition happening in this university. So that is the reason why it is giving me more happiness to stand here and to talk to you all, to give a welcome address. Firstly, for time constraints, I like to make this address very short. I like to firstly welcome
our Honorable Justice J. Chandran, Judge High Court of Madras, who's known to be a very popular judge, who has delivered a lot of judgments to develop the criminal jurisprudence of the country, which is not only nationally shared, but internationally compared, and also where many students of law get to know a lot of information through the judgments delivered by the Lordship. Many students here would know Honorable Justice J. Chandran as a judge of the High Court, but I would like to tell that Lordship has occupied many positions prior to becoming the judge of the High Court. And one such position was he was the secretary of the Law Department of Government of Tamil Nadu, where he has keenly shown a lot of interest to develop the legal education of Tamil Nadu. As a professor, I know that in various places, various committees, Lordship has been very particular to make sure that there cannot be no compromise in making sure that legal education should get the best. He never compromised as a secretary, and he has given his best. And I don't know how many of you know that Tamil Nadu National Law School was established during his period, where he was a secretary of Law Government of Tamil Nadu. My next welcome goes to Justice P.N. Prakash, sir, Lordship. Lordship is also a very, very famous, was a famous judge in the criminal portfolios whenever he used to give judgments from the criminal side and also in many other portfolios. Many of his judgments are being reported, discussed in the media, and also it has been discussed in classrooms, not only in law schools in Tamil Nadu, but even throughout the country. And sometimes I always think whether should call him as Justice P.N. Prakash sir or Professor P.N. Prakash sir, because he is more like an academician. And especially after his retirement as a judge of the High Court, he started to go to various law schools and start to talk to students, start to teach students. And it was a great gift for all the academia, all the legal academia, to hear his lecture and get enriched by Lordship's lecture. But at the same time, the bar and the bench will not leave Lordship that free. So shortly he was appointed as a special public prosecutor, National Investigating Agency by the Government of India. And the Supreme Court also was looking at his freedom in going to various law schools to give lecture. So the Supreme Court of India also designated him as Senior Advocate, Supreme Court of India, because they wanted Lordship to argue and make sure the criminal jurisprudence is again and again refined by his contribution, not only from the bench, but even now from the bar in Supreme Court of India. So getting these two judges to judge this finals and to be part of the valedictory is a great achievement for both the organizers, School of Excellence in Law and the Tamil Nadu Doctor and the Surana and Surana Law, International Law Attorneys. My next welcome goes to my Honorable Vice Chancellor, Colonel Professor Dr. N.S. SANTHOSH Kumar, sir. Sir, from the time he has taken the post of the Vice Chancellorship, he has given a lot of academic freedom. As a result of this, we are conducting so many programs within the campus and outside the campus. And academics is not only classroom academics. Today we have clinical legal education, we have field practice, we have court practical trainings, and all these things, legal aid clinics, non-theatrical, visual, audio-visual pedagogies, all these things are happening during the Vice Chancellorship of Professor SANTHOSH Kumar, sir. And sir, I welcome you, sir. This program would not have been possible without Surana and Surana holding hands with our institution. And a very popular firm, Surana and Surana. I need not talk about that popularity of the firm, but they have been contributing not only in the courts, but not only in the legal arena, but also in legal education. Very, very particularly, even we were discussing how they have the time, energy, and all the other resources to make sure that they are conducting, I think, more than 50 to 100 programs throughout the country, every part of the country, whether it's north, east, south, not only north, east, south, and west, but they are even looking at northeast, southwest. They're going to every direction of the country and they are conducting the program. So I really have to welcome in absentia Dr. Vinod Surana, sir, who's made sure that this moot court is happening here. And sir couldn't come here, but we have Kamal Kalyan Jabak, sir, the senior partner of Surana and Surana. He is a senior partner in the dispute resolution. His presence here in the valedictory is something great for our institution. And I'm sure, sir, this kind of greatness which you have shown to partner with an institution for the development of the student and the legal academia is something which history will talk about. Thank you and welcome you, sir. Preetham Surana, sir, was there for the inaugural also. And sir has been very carefully taking each and everything of this moot court. And teachers like me have to learn a lot from his various principles which he shown in organizing of this moot court competition. I welcome you, sir. It is always great for us to, have our alumni on the dais. And our alumni, Hari, Advocate Hari, well-known advocate from the criminal side of the Madras Bar, who studied in School of Excellence in Law. But the reason is for him sitting on the dais is not because he's our alumni, nor a good lawyer, but because he drafted the problem which all of the teammates have gone, all of the participants have gone through meticulously and would have found the various issues, problems which are coming out of it. So Hari has taken a lot of time in drafting it, and many people have appreciated the problem. Thank you, and welcome you, Hari. My special welcome goes to all the faculties who have come here, especially the committee members, Assis Stanley sir, Kadravan sir, Anbarsi ma'am, Vidusha ma'am. All of them have worked a lot for this program. So I welcome you all. Special welcome to Haja Hassan, Professor Haja Hassan, and Professor Paramasavam sir. Any program, they are there as pillars of encouragement, and they are making sure that any problem comes, they are immediately solving it without we think that there is a problem. Without the participating students, this program would not have happened. So we have students from throughout the country. I welcome all of you, the students of this institution who have come here for as an audience. I welcome you. The Moot Court Association, the association which is very popular in our country, I would say, because wherever we go, to any national law school we go, the Moot Court Association of School of Excellence in Law is what they inquire. So they are there. So that's what I told Dr. Vinod Surana also when we were talking earlier about conducting this moot. I was just telling sir that you can trust our Moot Court Association. They will organize it in the best possible way, which will make both of us proud. So I welcome the MCA students, especially Harani, the president of Moot Court Association, Dona, the vice president, Secretary Surya, and all the committee members. Because of time constraints, I am not telling all their names. My special thanks to and welcome to all those who I have not welcomed. And my special welcome also goes to the media and also to our official photographer, Darwin technical officer, and all the other people who have come here. Thank you very much.
Thank you, sir, for your insightful words that have set a powerful tone for this valedictory. Your vision continues to inspire us all. As we continue to honor the distinguished individuals who have graced this event with their presence, we now move on to the felicitation ceremony.
each of our guests have played a vital role in shaping the legal landscape, and it is our privilege to acknowledge their contributions.
I humbly request Colonel Professor Dr. N.S. Santosh Kumar, Honorable Vice Chancellor, the Tamil Nadu Dr. Ambedkar Law University, to felicitate our Chief Guest, Honorable Dr. Justice G. Jayachandran, Judge, Madras High Court. We request everyone to give a big hand. Your Lordship, your presence here today is a testament to the enduring connection between academia and the judiciary. Thank you so much for your presence today.
Our Honorable Vice Chancellor, sir, now shall extend our heartfelt appreciation to the Honorable Thiru Justice P.N. Prakash, retired Judge, Madras High Court, currently serving as the Special Public Prosecutor for National Investigative Agency. Your Lordship, your distinguished career serves as an inspiration to all of us here. Thank you so much for being here.
I humbly invite Colonel Professor Dr. N.S. Santosh Kumar, sir, our Honorable Vice Chancellor, once again to honor Mr. Kalyan Jabak, Senior Partner and Head of Dispute Resolution, Surana and Surana International Attorneys. Sir, please do the honors. Mr. Jabak, your leadership in the legal profession and your continued support for academic excellence are truly and deeply valued. Thank you so much for joining us today, sir.
Now, I humbly request Mr. Kalyan Jabak, sir, from Surana and Surana International Attorneys to honor our esteemed Vice Chancellor, Colonel Professor Dr. N.S. Santosh Kumar, sir. So your vision and dedication to legal education have been a pivotal and advancing the standards of our institution, sir. Thank you so much.
Now, a faculty co-coordinator of Moot Court Association, School of Excellence in Law, Mr. Assis Stanley Sylvester. Sir, I kindly request you to honor Mr. Preetham Surana, Dispute Resolution and Head of Academic Initiatives, Surana and Surana International Attorneys. Sir, your role in bridging the gap between academia and practice is invaluable. Thank you so much for staying with us during the entire course of events. Your patience is truly appreciated. Thank you, sir.
Now, I request Mr. Kadrivan, sir, Faculty Co-Coordinator, Moot Court Association School of Excellence in Law, now shall extend his token of gratitude to Mr. Johnson, sir, from Surana and Surana International Law Firm.
Now, I humbly request Colonel Professor Dr. N.S. Santosh Kumar, sir, a Honorable Vice Chancellor of Tamil Nadu Dr. Ambedkar Law University, to extend a small token of gratitude to Mr. Hari G. Ramasubramaniam, the proposition drafter of this exclusive Surana and Surana School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University National Trial Moot Court Competition. I kindly request our Vice Chancellor, sir, to give a token of appreciation to Mr. Kalyan Jabak in order to appreciate the presence of Mr. Johnson, requiring in his absence. As a token in need of absence, sir. So, Mr. Johnson, sir, has been serving as a pillar of support indeed. Thank you so much, sir. Thank you, esteemed dignitaries, for your gracious presence and for accepting our tokens of appreciation. Your contributions have indeed made this event a more meaningful and memorable one. Thank you all.
As we dwell deeper into today's proceedings, it is essential to ponder our cause of present, which has led our way to here. To shed light on this, I am privileged to introduce Ms. Vidusha Ma'am, Faculty Co-Coordinator of Moot Court Associations at School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University. Her dedication and hard work has been pivotal in organizing this event. I now invite Ms. Vidusha Ma'am to present the event report.
Respected Lordships, Honorable Vice Chancellor Sir and distinguished guests, it's my privilege, myself G.V. Vidusha, Assistant Professor, School of Excellence in Law. I'm here to present the report on this National Trial Advocacy Moot Court Competition conducted by School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University and Surana International Attorneys. As the Surana and School of Excellence in Law conducted this National Trial Advocacy Moot Court Competition 2024 comes to a successful close, we celebrate the reliable achievements and hard work of all those who involved. To take you through the organizer's journey during this competition, this entire report was drafted. This report is not only highlighting the exceptional talent of law students, but also demonstrating the unwavering commitment of the organizers who ensured its success. On February 14, 2024, School of Excellence in Law at Tndalu campus signed an MOU with Surana and Surana International Attorneys. This partnership aimed at elevate legal education through collaborative activities like seminars, internships, and research. A key highlight of the MOU was an annual moot court competition designed to immerse law studies in the complexities of our legal system. Upon the inception of the new criminal laws, it was decided to host a trial advocacy moot court competition. The preliminary works for the same began in the month of June 2024 amidst the formation of the MCA for the academic year 2024-2025. Therefore, this marks the conclusion of the first event of MCA 2024, and we, the organizers, are glad to have begun this academic year with this event in partnership with Surana and Surana International Attorneys. The moot problem was expertly crafted by Advocate Hariji Subramaniam, partner at Agra Legal, with assistance from a research team composed of MCA students. Advocate Hari also prepared the procedural test questions, ensuring they mirror the complexities of actual legal practice in short to shortlist the top 18 teams, which helped us in ensuring the competition in a smooth manner. With regard to registration, we kicked it off on July 19, 2024, sparkling the significant interest among law students nationwide. The competition problem and rules were promptly made available on the websites of both Surana and the MCA websites during the widespread attention which it brought. The registration for the competition closed on 11th of August 2024. The enthusiasm of the students was reflected in the impressive number of 35 number of teams which got registered, demonstrating the competition's appeal towards the law student audience. As mentioned earlier, in order to maintain the standards, a rigorous procedural test was put in place, ensuring that the teams were strong with the procedure of trial and criminal legal principles advanced so that it can help them in reaching to the oral stages of the competition. With regard to procedural test, which was held online on August 14, 2024, which determined the top 18 teams who were now present for the oral rounds on August 24-25 at our SOIL campus. The test comprised of both objective as well as descriptive questions, and one participant from the team was allowed to take the test. The teams were strictly monitored by the organizers during the course of test. The results were then announced by Mr. Preetham Surana, Head DRP Surana and Surana International Attorneys on the evening of 14th August 2024 from 6:30 p.m. onwards. Upon the release of the results, the top 18 teams for the competition were selected. With regard to memorial, the team submitted the soft copies of the memorial on 20th August 2024, and the same was scored by the set of 2 judges per memorial to ensure utmost precision and objectivity. The aggregate of the scores of both the judges were taken to calculate the memorial scores with the help of the hard copies as submitted by the teams on 23rd August. Following the selection of top 18 teams, MCA organized all necessary arrangements. The committee was divided into core activities supervised by faculty coordinators. Each team was assigned to address and ensure an equal proper queries addressed by all the faculty members along with the students who ensured a smooth process. The MCA also selected skilled students from SOIL as witnesses, assigning 4 witnesses to each team for the roundup to the quarterfinals. The semi-final saw the participation of the top 8 witnesses from the preliminary rounds and 8 experienced witnesses with the prior trial experiences. The orientation and inauguration for this event began on 23rd August 2024. The team received their new competition codes and were assigned to witness group comprising of 4 witnesses. The teams were oriented by Mr. Preetham Surana. Post orientation, the inauguration of the competition began with Honorable Justice Sounthar, Judge High Court of Madras, and Advocate John Satyan, Senior Advocate High Court of Madras, as the chief guest. Lordship declared the competition open. Soon after the same, there was a draw of lots for the participants to receive their sites. The fixtures were projected and the team did the memorial exchange. The preliminary rounds began on 24th August 2024 and there was total a panel of 19 experienced judges who actually judged all these teams. Upon the completion of both preliminary rounds, the results were declared by Mr. Preetham Surana. The team qualified to the quarterfinals are Wales Institute of Science and Technology and Advanced Studies, Symbiosis Law School, Hyderabad, VIT School of Law, TNNLS Trichy, Government Law College, Patrai Perumbur, Government Law College, Trivandrum, and Symbiosis Law School, Nagpur. The quarterfinals was adjudged by the division bench comprising of highly acclaimed advocates and began in the very same evening. Upon rigorous competition between all teams, the teams from Wales Institute of Science and Technology and Advanced Studies, TNNLS Trichy, Government Law College, Trivandrum, and Symbiosis Law School, Hyderabad were adjudged as the semi-finalists. Starting afresh, the semi-final rounds began on the morning of 25th August 2024 today. The teams were adjudged by the full bench consisting of Judge S. Karthikeyan, Judge A.S. Ravi, Advocate Pratap C.E., Advocate G.R. Hari, none other than the person who actually drafted this problem, Advocate Arun, and Advocate Harsharaj. Upon a long and strenuous round in both the court halls, the teams from Symbiosis Law School, Hyderabad, and TNNLS Trichy were adjudged at the finalists. The final rounds commenced post-lunch and the auditorium. We are truly honored to have Honorable Justice G. Jayachandran sir and Honorable Justice P.N. Prakash sir to judge the final rounds. Both teams showed great talent, determination, and skills. The same was audience by the other participants and the students of SOIL. Post the finals, now we are here in this valedictory of the competition which has just begun and it's been presided over by Honorable Justice P.N. Prakash, Judge High Court Madras, Special Public Prosecutor NIA, and Honorable Dr. Justice G. Jayachandran, Judge Madras High Court. We are also much grateful to have Dr. Vinod Surana, Managing Partner and CEO, Surana and Surana International Attorneys, and Advocate Kalyan Jabak, Senior Partner and Head, DRP Surana and Surana International Attorneys. Now, the partners are eagerly waiting to listen to the distinguished dignitaries as well as to hear the most awaited result declaration. This marked the end of the event report, and I hope the same took you through the experience of the organizers in conducting the event. Happy to present the report before the distinguished guest. Thank you.
Thank you, Ms. Vidusha ma'am, for your detailed report that has indeed covered the happenings of the event. Your insights remind us of the significance of this gathering. It is with immense pleasure that I introduce an illustrious figure in the legal community whose deep knowledge and vast experience have significantly influenced the practice of law. Mr. Preetham Surana, Partner of Dispute Resolution and the Head of Academic Initiatives, Surana and Surana International Attorneys, has played a pivotal role in advancing the legal profession with a visionary leadership. In the words of Marcus Cicero, the welfare of the people is the highest law. Dr. Surana's career embodies this principle, and it is with great honor that I invite him to deliver the special address. Sir, the floor is yours.
Honorable Justice, Honorable Dr. Justice G. Jayachandran sir, Honorable Justice Mr. P.N. Prakash, our Chief Patron, Colonel Professor Dr. N.S. Santhosh Kumar, my senior colleague Mr. Kalyan Jabak, Professor Dr. Gowri Ramesh, and Professor Balu in absentia, dignitaries on and off the dais, faculty conveners, faculty members, student conveners, MCA members, staff, media, students of SOEL, and my dear participants. It is my privilege to welcome you to the valedictory of this Surana and School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University of the National Trial Moot Court Competition 2024. As I mentioned in my inaugural address, that nurturing academic excellence is a way of life for us at Surana. Continuing further, during the dialogues and deliberation with members of the bar, the bench, and academia, over the in the recent past, on what are the important aspects of legal education which will play in the present and in the future. There were 4 points which I would like to place for you. The first point was simplification of language. Simplification of language and use of anecdotes for effective oral and written advocacy. The second, a mindset of conflict management and resolution required, that is to present legally and practically applicable solutions. Third is to promote use of technology in law practice and adjudication. Last but not the least, thrust on policy advocacy for greater awareness, original thinking, and leadership development. In view of time constraints, I will just mention on the first two. First was the simplification of language. While all the wonderfully educated people with elegant spoons in their mouths of grandiloquent words in speech and writing, and sesquipedalian documents have been relevant, and we can still jargon on big, wonderful, pleasing Shakespeare, Chaucer, and Wordsworth vocabulary. The debate was of its relevance in the future. The changing face of society, which is based on inclusive democracy, particularly for people who speak English as a second language, and those with disabilities, I'm talking about language disabilities with lower levels of education, indicates that the world will move to more plain and simple language when communicating. This stems from the fact that today people have a right, or people are more aware about their rights to understand what they are being asked to do and what their rights are and what they are entitled to. Well, on this point, there is a peep we have had into the future when back in October 22, New Zealand bid its farewell to these jargon words and introduced the Plain Language Act. The big question then was to be or not to be. And the B side, they got 65% of the votes, and the bill was ultimately passed with support from the Labour, Green and Maori parties in New Zealand. So henceforth, since then, New Zealand uses plain language in its bureaucracy, which the favorers show that it saves a lot of time, government time, saves money, and communications are very clear, and that is a key to a functioning democracy. Back home, back in India, over the last year, the Society of Indian Law Firms is propagating the use of plain, simple language. The second point, which I would like to place before all of you, is the regards the mindset of conflict management and resolution, that is to move towards more legally and practically applicable solutions. Historically, conflict resolution in India was what we call ADR today, that is mediation, negotiation, and conciliation. Back then, we were like self-governed, where panchayat, that is 5 elders of a community, would in a town or the community or the city gather and go about resolving issues effectively, which was a non-adversarial approach, rather than the adversarial approach that we follow through litigation and arbitration, which is actually the ADR, if you see from the historical perspective. The panchayat used to make the parties involved sit together after dispute resolution, break barriers and the bridges for connect, or I would rather say to reconnect over a meal. Whereas the adversarial approach which we follow today, which is actually taken from foreign civilization and foreign culture, which is not akin to what India used to do traditionally, is more on the win-lose, factor rather than the win-win factor, which the historical way we used to go about resolving our conflicts. I would not take further time, as just after me there are legal luminaires from whom I'm sure we all are looking forward to listen to. But these are the points I just wanted to place before. So this is a food for thought for us to dwell and think how and what would be the way for us forward. Thank you and Jai Hind.
We are truly honored, sir, by your profound insights you have shared. Your presence today has added tremendous value to our competition. And now we move on to the most anticipated moments of the day, the declaration of results and prize distribution. The culmination of hard work, dedication, and legal acumen will be recognized and rewarded. Over to Mr. Preetham Surana, sir, partner of dispute resolution and head of academic initiatives, Surana and Surana International Attorneys, for declaration of results and distribution of prizes.
No, we'll go by the order. Sorry. Right. Okay, so we Well, the lordships have instructed me to announce the results without without any further delay and ado. So the lordships are lordships, and I shall abide by the order placed before me. So I will go through it quickly without adding much. I apologize for the lordships, since I would have skipped my part of the rendition, rather than we would have preferred to listen to your views. Okay, I start with, in the meanwhile, I would request Professor Dr. Ajit Uman Abraham, Advisor, MCA, and Associate Professor, Head of Department of Cyber Space Law and Justice, to please come forward and give away the prizes. The first one is the 4th Best Memorial, which goes to Team Code TA15, Chennai Dr. Ambedkar Government Law College. This is team consisting of Muhammad Arbaz Khan, Satyanarayanan, Mahalakshmi, and Purvasan. Congratulations to you. Next, team TA09, they are the 3rd Best Memorial, and they share this with TA18, the Symbiosis Law School, Hyderabad. Both of the teams, please do come forward to receive it. Team number TA09 first will come on stage once they move, and then followed by TA18. TA09 and then TA18. This is the team TA09, and they shared the 3rd Best Memorial with TA18, Symbiosis Law School, Hyderabad. Please come on stage. Please come on stage. All the best. Symbiosis Law School, Hyderabad. That is the 3rd Best Memorial. They were part of the finals. Okay. Well, they're having their, as we would back then say, Kodak moment. I would now announce the 2nd Best Memorial, which is a cash prize of rupees 5,000. This goes to team code TA11, Marathwada Mitra Mandal Shankar Rao Chavan Law College. The team consists of Kirti Singh Vagela, Chintan Kumbharikar, Akshay Hande, and Arya Balsare. They are the 2nd Best Memorial. They have a cash prize of rupees 5,000. The Marathwada Mitra Mandal Shankar Rao Chavan Law College. I would request the teams to come fast when I announce the names. Lordships have to go. The Best Memorial goes to Team TA17, the National University of Advanced Legal Studies, Kochi. The Best Memorial, they get a cash prize of rupees 10,000. This is Bliss Joseph Segi, Arvind Sankirtana, and Mishab Hamza. Please pardon me if I am not pronouncing your names properly. Now we will honor the and acknowledge the contribution of the witnesses. The fourth best witness goes to Team TW3, Vijay Krishna, Mangai, Nishant, Pradeepan. This is the fourth best witness. Please come forward fast. The third best witness, please be ready to come. That is Team TW10. Shri Trisha, Subhash, Tarunika Varlakshmi, and Tejaswin. Please come forward, TW10. Are you here, TW10? Yeah? They are the third best witness. Please enter to that side and come from the side where I am standing. Exit from my side, so it becomes easy. Team TW10 getting the third best witness. The second best witness goes to Team TW18. This consists of Kaniga, Kavya, Madhumita, and Mahani Vedita. And now I will announce the best Law College. Congratulations to the witness for your contribution to this competition. We will now move to the individual category, which is the best student advocates, which is based on the preliminary round results. The fourth best student advocate goes to Darshini of Wales Institute of Science and Technology and Advanced Studies. Darshini, are you here? TA01? Seems she is not here. Okay, we'll move to the third best student advocate. This also goes to the same team, Adut Malik Arok of Wales Institute of Science and Technology and Advanced Studies. Wales Institute of Science, Technology and Advanced Studies. That's Adut Malik Arok who's coming. Please also give her Darshini's prize. She's from the same institution. We now move to the second best student advocate. This goes to Jyotsna of TA03, the Shastra deemed university. She gets a cash prize of rupees 5,000. The second best student advocate. Come fast, double up please. Shastra deemed university. Now, the best student advocate, the big one. This goes to TA18 Rohini Pandey from the Symbiosis Law School, Hyderabad. She gets rupees 10,000. a sum of rupees 10,000. Congratulations, Rohini. We will now move to announcing the team placed third. That goes to team TA17, Nuals, Kochi. That is Bliss. Placed fourth. From Nuals, Kochi. College, Tirunantapuram. Okay, now the big one, which I'm sure we all are waiting to know about, the winning team. Any guesses here? No time for a guess, I guess. So this moves to team TA18, Symbiosis Law School, Hyderabad. That's Rohini Pandey, Kanishka, Tarini, and Shreya Bose. They get a prize of rupees 40,000. They are the winners, winning team. Symbiosis Law School from Hyderabad. They would be getting a check of rupees 40,000. A big round of applause. The runner-up team on stage, the Tamil Nadu National Law University, TA02. Please come forward. Lakshya, Leo, Abhinaya, Lakshmi Shushila Ramchandran, and Arivi Sudhar. The runner-up team from the Tamil Nadu National Law University, they get a cash prize of rupees 20,000. Just hold on. While the team is on stage, I'll just make one more announcement. That team member, Arivi Sudhar, is the best speaker of finals. I have one more award to announce. Not for them, you can move. So we at Surana and Surana laid down high standards in mooting, and we have an award called the Spirit of Surana, which symbolizes the holistic participation of a team with who participate, who have the attributes of team solidarity, participate in goodwill and harmony, spirited and healthy competition, of course, and they have good argumentative skills. This particular thing is voted by the participants for the other participants who are competing in the competition. And the organizing committee of the host school has the veto if there is a tie to choose a team, stating the reason. So this particular Spirit of Surana goes to TA17, the National University of Advanced Legal Studies, Kochi. This is again Bliss, Joseph, Segi, Arvind, and Sankirtana and Mishap for you. That's the spirit of Surana participating in the right spirit. Thank you, Lordships. I request you to please take the seat. Just one last formality which I have to do is uh, from the Surana and Surana team here, we would like to acknowledge the team from SOEL for putting up and organizing a wonderful show. We would like to just give a token of our appreciation. The team from representing SOEL may please come on stage, the organizing committee team, the faculty conveners, please come on stage. And I would request Ranjit sir and Christy sir to please join on stage. I would just say thank you to all the stakeholders.
I, on behalf of the Tamil Nadu Dr. Ambedkar Law University, extend a heartfelt gratitude to Lordships for taking your time, and due to time constraints, we would now move on to the national anthem. Thank you, Lordships, and I request everyone to kindly rise up for the same.
जनगण मन नायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल वंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तिरंगा तव शुभ नामे जाहे तव शुभ आशीष माहे गाहे तव जय दाता जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Thank you, everyone who made this event possible. And until we meet the next time, this is the Moot Court Association of School of Excellence in Law, the Steins of. Thank you, everyone, and I hope you have a great week ahead. Thank you.